I'm going to get started. We have a lot of individuals on the call. I'm glad to see all of you. My name is Linda Campbell. I am the House Chair on the Joint Committee on Advanced IT, the Internet, and Cybersecurity. A lot of material to cover, one committee, but all very timely. And today we're going to be focusing primarily on two sets of legislation categories, if you will. We have a broad spectrum of bills in the committee, but today we're going to look at a couple of one is issues and legislation pertaining to broadband access, and the other are issues around equity around broadband access. And the other issue the other issues are around data privacy. So two large groups, if you will, two categories of legislation that we'll be looking at primarily today. I'm going to be joined by my very respected colleague, Senator Barry Finegold, who will be with us very shortly here. And because of the large number of bills that we're going to be looking at today, I ask that all of you respectfully keep your testimony around 3 minutes, if you would. That will be helpful to others as we go through those that have signed up. As always, we will take our legislation. As we all know, there's an awful lot going on right now in terms of legislation and committee hearings in the State House, and my colleagues will be joining us as they are able to testify, and we will recognize them when they join us. I would like to mute your sound on your computer as we start. That would be really helpful. I'll do of that as we go through. I often need reminding of that myself. So I just would like to introduce the committee members who will be joining us on and off as we proceed through this hearing. So on the House side, we have Vice Chair Carey. We have Reps Ramos, Farley-Bouvier, Gianano, Senna, Robinson, Rep Machino, Rep Kearns, Lombardo, and Durant. And on the senators, for senators joining us today, we have Vice Chair Moran, we have Senator Lesser, Senator Montigny, and Senator Fatman. So they'll be coming in and out of this hearing, and some of them will be testifying as well. So I want to welcome all of you. If you have something that you need to relay to the committee, we have two fantastic committee research directors on with us today. Please just mention something in the chat, and they will keep Senator Finegold and I aware of anything that you need to say administratively during the hearing. So without further ado, as we get into these two categories, I would like to see if Leader Frank Moran from the House is here to testify, and to recognize him to testify. Leader Moran, are you with us yet? Okay, we'll be looking out for him. We also have Rep. Dave Rogers, who wished to testify on House 134. Representative, are you here with us yet? Okay, see, starting on time sometimes can be a liability, right? We'll be circling back. Senator Michael Moore had signed up to testify as well. Senator, are you with us yet? Okay. Senator Eldridge, are you here with us yet? Okay. Rep. Senna, are you here with us yet? Okay. If my team here has any of the legislators that sign on or join us, please just let me know via text, and we will fit them in very quickly. Okay, so I am probably going to so please just note, we'll fix that. And again, for those of you just joining, please mute so that we can clearly hear everyone's conversation. So the first person that I have on my list to testify is Cecilia Doucette on Senate 5-8 and House 1-5. Cecilia, are you here with us yet?
I am. Thank you very much. My name is Cecilia Doucette, and I am the Director of Massachusetts for Safe Technology. I helped Ashland Public Schools become the first in the nation to begin taking precautions around wireless technology. Rep. Dykma's House 115 and several of Rep. Duffy's bills address toxic EMFs, or the electromagnetic fields of microwave radio frequency radiation pulsed from our personal devices and routers, from cell towers, 5G small cells, and utility smart meters. As the pandemic has taught us, we need to be vigilant about invisible toxins. On this radiation detection meter, we see my home is in the green. We simply access the internet through Ethernet cables and these little adapters that you can hook up to tablets and into cell phones. Watch what happens though when I turn my cell phone on and we see everyday exposures coming out of this one device. And then imagine what this looks like for our children when we have active Wi-Fi transmitting. Let me see if I can get that to show. When we have active Wi-Fi transmitting in our classrooms from multiple devices. Now, the scientific literature tells us that we should be at 0.1 microwatts per square meter of this radiation. And right now, from one device, we are at 121,000 microwatts. That's 1,000,000 times too high from where the science is telling us. So the science shows this is a neurotoxin and an immunosuppressant. Even pre-pandemic, our children were grappling with an epidemic level of anxiety, depression, insomnia, cognitive impairment, and other chronic illnesses. We have now given every student in the Commonwealth a wireless tablet to access their education with absolutely no safety instructions. Again, all we need to do is plug it into an Ethernet cable and get an adapter, and we've solved the problem. Thankfully, when we met with New Hampshire legislators, they passed a law in just 7 months' time. Rep. Dykma's bill has been languishing here for 6 years. New Hampshire's groundbreaking majority report documents the science and conflicts of interest with the wireless industry and our captured federal agencies. The meat of the report is just in the first 17 pages, including 15 recommendations to educate the public, transition away from wireless build-out, hardwire our schools, monitor radiation exposure levels, protect our natural environment, and amend the Telecom Act of 1996 that allowed all this wireless infrastructure in. We can have excellent technology and close the digital divide, but only with future-proof, high-speed cable or fiber to the premises. Then again, simply just pick up with Ethernet cables and adapters inside our buildings. The industry will sell you what is easiest and most profitable for them. COVID funding can help pay for responsible technology, and there is also funding available for Massachusetts to recoup from something called the Irregulators lawsuit that New York has already taken advantage of. Please pass House 115 now as an emergency measure to protect the Commonwealth's children. The nonprofit Wireless Education has quick online courses ready to train the children and the staff. I have already worked with the Massachusetts Department of Public Health, and in 2016, we wrote an EMF fact sheet that has yet to be released to the public. So please,
Thanks
experts are
so
here to
much,
help.
Cece. Time's up.
Experts are here to
Thanks.
help at every turn. So thank you for your time, and I would be honored to answer any questions you may have.
Thank you so very much. I will put it out there to the committee members. If anyone has any questions, concerns. Okay, thank you. And I assume you've provided us some written testimony.
Yes, I'll be sending that in by Friday. Thank you.
Okay, thank you so very much. Okay, next on my list, I have Dr. Lisa Nagy. Did I pronounce that right, Lisa, if you're here? Is Lisa here? Okay, we will circle back. Next, I have Ken Gartner to testify on House 108. Is Ken here? Okay. How about Kirsten Beatty? Is
Wait, here. I'm here. Ken Gartner is here.
Excellent. Thank you very much. And I believe you're here to testify on Senate 220. Is that correct?
I was thinking H108, H109, and H111.
Okay, they're probably very similar in their orientation. That happens similarly, trying the topics together. That's excellent. Okay, the floor is yours, Kristen. Go ahead.
All right, good afternoon. My name is Ken Gartner. I live in Warren, Massachusetts. I have an electrical engineering degree from MIT. I'm speaking in favor of the several proposed bills, H108, H109, and H111. These bills mention building biology exposure thresholds, and I will briefly explain them today. Building biology is a compassionate discipline that works to ensure that people live in the most healthful environments possible. Modern living involves exposure to many hazards, some obvious and some subtle. A building biologist is often requested to visit a home due to a resident's health challenge, and then it is their mission to help identify and perhaps lessen such hazards in that home, based on decades of accumulated expertise. One of the central tenets of building biology is called the precautionary principle. In this context, to err on the side of caution instead of waiting decades for full scientific confirmation of negative health effects. Building biologists often quantify hazards using measurement instruments and then compare those values with known healthful levels. But the goal is always to holistically examine the situation and provide the necessary support to offer the best opportunity for an improved health outcome. Building biology exposure threshold levels are broken into 4 categories representing different severities of exposure. The most benign level is named no concern and reflects a very low exposure and would best answer the question, what level is safe? Progressively, there are levels that represent slight concern, serious concern, and extreme concern. These thresholds were determined by 30 years of iteration, working with seriously ill people in their homes, noting which exposure levels correlated with symptom elimination. Can an otherwise healthy person be exposed to a higher threshold for a short time with no lasting negative consequences? Perhaps. We just don't know the answers today, so it would be a calculated risk for that individual. It is an unreasonable assumption to ask for a safe exposure level to a toxicant and expect a simple answer. The number of factors involved are myriad and understudied. The nature and duration of the exposure, the biological mechanisms that absorb, react, and detoxify, the presence of cofactors such as heavy metals, and the inherent robustness of some individuals. The existing EMF exposure standards supported by the FCC, the IEEE, OSHA, and numerous agencies do not adequately consider the long-term exposure for 100% of the population, including newborns, the desperately ill, children, pregnant mothers, and so on. They are halfway measures, neither based in biological science nor on observed human health, and serve no one's best interests. The building biology exposure standards for EMFs are likely the most honest in the world, as no economic trade-offs were part of their genesis. And honesty is what is needed when discussing human health. Thank you.
Thank you very much, Ken. And I'm sorry I was moving too fast there and then went right on down the list. But thank you for your patience and keeping it to a respectful amount of time. I want to see if there's any committee members who have any additional questions here. And I'm not seeing any. And I am told that Senator Eldridge is here to testify. And Senator, thank you for taking the time to be here. And the floor is all yours.
Great. Thank you very much, Chairwoman Campbell, to the members of the Joint Committee on Advanced Information Technology, the Internet, and Cybersecurity. And thank you so much for taking me out of turn. And I'm here to testify on my net neutrality bill, Senate 48, an act to ensure a free and open internet in the Commonwealth. And this really is a very bipartisan issue, is that we should make sure to have an open, free, and neutral internet, and that of course means in Massachusetts as well. What we do know is that the Trump administration repealed the net neutrality provisions that were originally established by the Obama administration in 2015. And despite the best efforts of our United States Senator Ed Markey, who is the lead Senate sponsor on the Net Neutrality Act in Congress, that has not yet passed. And so it's really, a need for state leadership, and in a state that is so reliant on the internet and so focused on high tech, we really should be the lead on this. And so what this legislation does is it would make net neutrality the rule of the Commonwealth in Massachusetts. So it would specifically block internet service providers, or ISPs, from blocking, manipulating, or otherwise discriminating against legal web content. And that could mean slowing down a certain website. It could mean, blocking, certain content from certain websites. So, this has happened across the country in certain instances. And so we really want to take a lead in Massachusetts. I don't think I have to tell anyone here that the internet is valuable as it was before the pandemic for school kids, for all of us working from home, to critical, public safety and healthcare actions. The internet became so much more important and really sort of a life need for all of us. And so this legislation, again, would prohibit an internet service provider from blocking or slowing down access. And when you think about the grassroots movements, when you think about advocacy for all of us as elected officials, having that free and fair access to the internet is so critical to strengthening democracy in Massachusetts. So respectfully ask the committee to consider the bill and reporting it out favorably. And I do really think that Massachusetts should be the lead on this. And again, thank you so much for taking me out of turn. I really appreciate it.
Senator Eldridge, this is Senator Finegold. What's the status of the bill in DC right now? Do you have an update on that?
Yeah, thank you, Chairman Finegold. So Senator Markey, and again, this has some bipartisan support in the U.S. Senate, and right now, unfortunately, like most bills in the U.S. Senate, it's up against the filibuster, and so the bill, of course, has been filed this session, but it has not come up for a vote. And unfortunately, though there is some bipartisan support, the 60 votes not there yet to pass the bill, and so it's in committee right now, and I think without national or federal action, it's an opportunity for Massachusetts to take action and apply more pressure for Washington D.C. to take action as well.
Thank you very much, Senator. As Senator Finegold and I think I've said before, we have a window of opportunity here to address some of these issues as we move forward with federal funding as well as a tremendous impetus and need that our constituents have to address these issues. And I just want to pivot before we recognize Milan, who just joined us. Senator Finegold, do you have any comments that you want to share before we continue on?
I just want to echo about the importance of privacy, and we want to, do things similar to what has happened in looking at in Virginia, California, but data privacy is a top priority. But we want to craft something that is fairly balanced and making sure that, you know, there's something that we can all be proud of that will not only work for Massachusetts, but work for the rest of the country and the world as well.
Yes, thank you so much. And I, you know, again, pretty much everything before this committee is, I think, an opportunity that we have with a small window. So, Senator, thank you. I'm sure we'll be having more conversations on this. There's a lot of support for this issue. So,
Thank you so much.
Madam Chair?
Yes. Question,
Sorry, I had a question for the senator, if you don't mind.
please.
Senator, thank you so much for bringing this before us. You mentioned that it applies to ISPs. Does that mean just broadband connections within residences or businesses within buildings, or will that also include tethering from wireless phones? Because I think as we move towards 5G, there's going to be increased reliance on just having an internet connection through your phone that tethers to your laptop or your television. So just want to see what the scope is here. Thank you.
Yeah, thank you so much, Representative Robinson. So yeah, so the bill does mention tethering, but I think probably it could be strengthened because, to your point, the movement away from you know, just internet service providers at our homes or buildings and more to hotspots and the internet through our phones. And so I think that is an area perhaps where the committee could strengthen the bill. So it does mention tethering, but I think the bill could be strengthened to make sure it's truly comprehensive.
Thank you so much.
Further question? Okay, I'm not seeing any here. I'd like to pivot to welcome Leader Frank Moran. Mr. Leader, are you still with us?
I'm still with you. Can you hear me?
I can hear you loud and clear. Thank you. Go ahead. The floor is yours.
Buenas tardes. Thank you to Chair Campbell and Finegold, and to you, to the members of the Joint Committee on Advanced Information Technology, the Internet, and Cybersecurity, for giving me the opportunity to speak in support of my bill, H131, an act creating the Massachusetts Digital Equity Broadband Adoption Program. As we are all now aware, the COVID-19 pandemic exposed long-standing socioeconomic and racial disparity within the certain sectors of Massachusetts, with inequitable and lack of reliable access to the internet being some of the most prominent. And while many in our states were able to smoothly transition to a work from home or remote learning routine, there were countless workers and students who were not afforded such a luxury. This was especially prevalent in gateway cities, such as my hometown of Florence, where students who did not have reliable internet access in their home had to be provided with Wi-Fi hotspots through the schools or nonprofit organization. Esto fue especialmente frecuente en gateway cities, como mi ciudad natal de Lawrence, donde los estudiantes que no tenían acceso confiable a internet en sus hogares debían contar con puntos de acceso Wi-Fi a través de sus escuelas y organizaciones sin fines de lucro. H131 will prevent this issue from becoming more widespread in the future by establishing the Massachusetts Digital Equity Broadband Adoption within the Federal Office of Housing and Economic Development. This program is designed to expand the availability of broadband internet access through the state, while also providing financial relief to eligible residents who cannot currently afford it. Eligible individuals will have the opportunity to receive financial assistance in the form of vouchers designed to reduce the costs or fees associated with the installation or activation of broadband services, as well as their monthly subscription costs. To ensure this program's success, the Executive Office of Housing and Economic Development will be required to coordinate with the Department of Elementary and Secondary Education to send information about these programs to families who have students enrolled in K-12 schools. Additionally, anyone currently receiving SNAP, transitional aid to families with dependent children, or Medicaid, as well as household with a child receiving free or reduced school lunches, will be deemed automatically eligible for this program. H131 also creates a broadband adoption digital equity fund to support the implementation of this program that will be administered by the Secretary of Housing and Economic Development, allowing for his long-term success. The unprecedented events of the past year have proven the urgent need for such a program to be implemented in Massachusetts to support our most vulnerable students so that they may learn at the same rate as their peers, as well as adults, as much of the job-seeking process is now entirely based online. I also believe that this legislation will build upon the ongoing efforts and long-term goals of the newly established Broadband Equity Commission to create an equitable, accessible telecommunication infrastructure that benefits all regions of the state, as well as our low-income communities. Thank you for your time and attention to these important matters, and I respectfully request that this legislation receive a favorable recommendation by the committee. Muchas gracias, Chair Campbell and Chair Finegold.
Gracias por su tiempo. Excelente. Thank you, Representative Moran, and we admire your advocacy, and that is something that the Broadband Equity Commission that I co-chair with Leader Golden, and exactly what you're talking about is what we want to accomplish. So completely agree with your advocacy, and we hope we're going to get something done the next month or so.
Muchas gracias. Your Spanish is getting better.
It has a long way to go, though, Leader Moran. But thank you again very much. And you know, again, I think there's a tremendous support for this in the legislature, and it's important to a lot of individuals. And one of those would like to speak, and that's Rep. Bouvier. Rep, please, the floor is yours.
Y muchas gracias también, señor. Muchas gracias. Y, en Pittsfield también tenemos ese problema. We need to understand something new about broadband. That as you said, Leader Moran, that I mean, I've been talking about broadband equity for many, many, many years, but I did so on behalf of the surrounding towns in Berkshire County. You know, Pittsfield's the big city around here. That's going to sound a little funny to all of you, but in Berkshire County, Pittsfield's a big city. And so I would be advocating for places like Monroe and Shelburne and you know, Mount Washington to get broadband. And they've done tremendous amount of work just to get the fiber laid. What we understood in the pandemic is that more than 12% of the students of Pittsfield did not have broadband access. They could literally not do their schoolwork because they didn't have it. And you're not going to be surprised to hear me beating up on big corporations in any of my testimony, but Verizon and Spectrum were horrific here in Berkshire County in that they pretended to be the good guys and said, we'll offer free internet for 3 months. You know, school years don't last 3 months, by the way, to families, but only those families who do not have an overdue bill. So now we can imagine what that looks like. So this is a tremendous problem. We need to bring this equity in, whether that is getting broadband, for example, into neighborhoods, into specific neighborhoods, or bring them into particular housing projects. I can't thank you enough, Leader Moran, for leading on this, for your strong and determined advocacy, and for all the people who are working for broadband equity in every single corner of this Commonwealth. Thank you so much for allowing me to speak, Madam Chair.
Thank you, Rep. Appreciate your support.
Yes, it definitely is a statewide issue, and you definitely have spoken on this consistently for a long period of time. But, you know, as with many of these equity issues, you know, the pandemic has made things come into sharper focus. And we really do appreciate you taking the time to be with us today to highlight that. And again, between the commission and this committee, there is a great deal of interest in this issue. So thank you again for your time. Okay, I'm going to circle down again to Kristen Beatty. I went through this list. I was flying through this list a bit too quickly, But Kristen, are you still with us and would you like to testify?
Can you hear me?
I can.
Okay, great. I have a quick question. I'm trying to speak on all the bills that I have. Can I speak on each bill, or do I only have three minutes?
3 minutes, but understand also that you will have access to us to meet on this legislation as well, okay? But if you could, simply because there's so many here to testify today, if you could limit it to 3, that would be very helpful.
All right, I'll begin then. So I would like to point out that there are a ton of studies. For example, in California, there was a bunch of firefighters who for 5 years had a 2G antenna on the fire station. And in the German, in Russia, they studied thousands of Russian workers. And in the present time, they also have studies that are all coming with the exact same parts that people have, that people who are exposed over that time, they have cognitive impairment, headache, insomnia, irritability, depression, edginess, heightened stress response, digestive complaints, EEG changes, hyperactivity of the thyroid. They also have paranoia, hostility. And I'm pointing out that because I think that today in our time, we have a problem that a lot of people have an attitude or are ill and also have a hard time concentrating. And so for youth, I checked the statistics, and before the pandemic, 33% of teens had an anxiety disorder, and that was in 2004. And there's all these statistics that are just like that. And I know that they've linked those problems to using digital media. However, I think that when you look at the impacts of the wireless and all the research and all those people, that you can say that that's a major contributing part. So what I'd like to ask is that you support an act to, well, I'll just say an act to regulate screen time in early and K-12 education. And also the bill that I wrote to reduce radiation in schools, an act reducing non-ionizing radiation such as wireless. For that bill is requiring that every public school and university reduce exposures as they can in their means. And that means that they immediately take action, whereas the other bill is going to send it to study to the Board of Education, and then that will take time, and then it could be influenced by who knows. Also, there's an act requiring the wireless insurance could be a possibility to help prevent all the wireless, because apparently the wireless providers are not carrying quality insurance, and they're pretending to do so, but they're putting people as fronts for their organization to carry the insurance. So I think that would be important to require. So, and then just so you understand, in terms of the tech in schools, I'll just complete this quick. The tech in schools, the problem is it's very attractive to communities because it's very cheap, and because accountability requires they have a lot of the data. And then, so because of that, they're moving more and more towards tech. And so I think that we need to take action to put the limits in schools. I appreciate your time.
Well, thank you for taking the time to speak with us. And that was a lot of information to cover in a very short period of time. And again, feel free to reach out to us and also to submit to us some testimony in writing. That will be very helpful as well. And again, thank you for wrapping those three things up in a very respectful amount of time. So are there any questions from committee members? Okay, seeing none, I am now looking at a panel headed up by Kristen Grazazio. Kristen, are you with us still?
I am here. Thank you, Chair.
Can you pronounce your last name better than I did, please?
It's a Grazioso.
Grazioso. Okay, excellent. Okay, I was close. Thank you very much, and the floor is yours.
Thank you. Good afternoon, Chair Finegold, Chair Campbell, and members of the Joint Committee on Advanced Information Technology, the Internet, and Cybersecurity. My name is Kristen Grazioso, and I'm the Director of Legislative and External Affairs at the New England Cable and Telecommunications Association, also known as NECTA. Here at NECTA, we represent substantially all cable broadband providers in the Commonwealth. I'm also joined by my colleague, Tim Wilkerson, who is the president of NECTA, who will be offering comments after I finish up related to some of the broadband bills before you today. I appreciate the opportunity to testify in support of House Bill 131 and Senate Bill 57, enact creating the Massachusetts Digital Equity Broadband Adoption Program, sponsored by Leader Moran and Senator Barry Finegold. Our members are committed to increasing broadband adoption and digital equity, and with unprecedented federal support for broadband flowing to Massachusetts, legislative leaders have a once-in-a-lifetime opportunity to close the digital divide in the state once and for all. We believe the principles outlined in House Bill 131 and Senate Bill 57 will help achieve that goal. First, when it comes to broadband infrastructure, Massachusetts is a national leader in deployment. Today, over 98% of Massachusetts residents and businesses have access to high-speed broadband. Given the advanced coverage and networks throughout the state, the primary challenge we see when it comes to bridging the digital divide is not physical access to the internet, but rather the adoption of that internet service. We know that financial insecurities, access to computing devices, lack of digital literacy or skills, or other challenges like language barriers have really prevented too many families from adopting broadband. And I think Leader Moran's testimony really honed in on the issue, particularly in those cities, gateway cities, and families really struggling to afford internet subscriptions. So to help break down remaining barriers, broadband providers in Massachusetts have invested millions of dollars in programs to help individuals facing financial insecurities get connected to the high-speed internet service available at their home. Programs like Comcast Internet Essentials have been around for over 10 years, offering low-cost, high-speed broadband for $9.95 a month with subsidized computing devices like laptops and digital literacy training in various languages. Charter Communications Spectrum Internet Assist is also a similar low-cost program, and these companies expanded eligibility during COVID-19 to reach as many families in Massachusetts as possible. While these programs are making strides, we know that there is still work to be done. House Bill 131 and Senate Bill 57 seek to address these remaining digital equity challenges and implement permanent long-term connectivity support for those in need. As Leader Moran had said, House Bill 131 and Senate Bill 57 creates the Massachusetts Digital Equity Broadband Adoption Program, which is a mouthful. So I'll be referring to it as the Massachusetts program further in my testimony. But the goal of the program is to provide financial support to eligible families to subsidize their internet connection and provide the equipment, tools, and training necessary to help them take full advantage of the internet. Specifically, the program would deliver support in 4 critical areas. Subsidize the low-cost, high-speed broadband subscription, subsidize the installation and in-home equipment like routers and Wi-Fi extenders, subsidize computing equipment like laptops or tablets, and then finally, the 4th piece, provide digital literacy programming that delivers foundational and advanced digital training and workforce development to help families with the tools they need. I think it's important to note that these bills were filed prior to the creation of the FCC's emergency broadband benefit, which provides a discount of up to $50 per month towards broadband service for eligible households currently. So we would just say, because of this new federal program, we would urge the committee to amend the legislation to ensure that any Massachusetts broadband adoption program coordinates with and complements the federal program to really fill in the gaps that do not exist right now with the existing program, and then avoid duplicating benefits. And so, I know my time is up, so I'm happy to answer any questions or talk further about some of the specifics of the EBB. But, we do believe that allocating federal funds to encourage internet adoption and support enhanced digital literacy programs is the approach that will provide the fastest and most equitable path to ending the digital divide in Massachusetts, and really ensure that every resident in the state has the opportunity to connect to the internet. We, are ready to partner with the committee on these efforts, and happy to either turn it over to my colleague now to talk about some of the other issues that we're here to testify on, or answer any questions related to this bill. Thank you very much.
You're welcome. A lot of information in a very short period of time.
And I should have said at the outset, we submitted extensive written testimony on this issue, so I'm looking forward to your review of that as well.
Okay, well, thank you. That's extremely helpful. A lot of the members on this committee, this topic is new to us, so the more information, the better. So that's really appreciated. Before we do go on with Timothy's testimony, I just want to say on this particular bill, do any committee members have any questions or follow-up comments that they would like to present at this time? Okay. Then, as you mentioned, Timothy Wilkerson is joining you as well. And Timothy, the floor is yours.
Excellent. Good afternoon, co-chairs, esteemed members of the committee. There are several policy proposals before you that fall under the rubric of broadband regulation, including net neutrality, mandating internet speeds, and establishing broadband pricing. While well-intended, we respectfully offer that these bills are unnecessary, violative of federal law, and will not further the goal of ensuring equitable connectivity across our Commonwealth. The realities of the broadband landscape are clear. Hundreds of millions of dollars have passed in ongoing private investment, and successful public-private partnerships ensure that Massachusetts consumers have an open, reliable, and world-class broadband, and that this infrastructure is the backbone of our leading innovation economy. I'd like to first address net neutrality. NECTA members do not block, throttle, or interfere with the lawful online activity of our customers, and have reaffirmed these commitments time and time again since the FCC first articulated these open internet principles in 2005. It is important to underscore that these commitments are more than a pledge to our customers. They are part of our company's operating DNA. However, if an ISP violates these principles, there are strong existing federal and state laws that would permit the state attorneys general, the Federal Trade Commission, the FCC, and the Department of Justice to open investigations and bring penalties against any company failing to uphold these principles. NECTA believes that federal legislation codifying these protections under a clear, modern, and enduring framework, along with existing state and federal enforcement authority, will prevent unnecessary disruptions and unintended consequences that would ensue from a patchwork of state ISP regulation. Lastly, states are likely preempted from imposing state net neutrality regulations on ISPs, but states should not attempt to regulate an inherently interstate service such as the internet, particularly when at a minimum, federal action on this issue is likely to occur under a Biden-controlled FCC. Now turning to the general broadband regulation bills. In response to COVID-19, Massachusetts broadband providers took unprecedented steps to ensure that Massachusetts families and businesses stay connected. At the onset of the pandemic, all of our members signed the FCC's Keep Americans Connected pledge and committed not to impose any late fees or disconnect service for non-payment. The companies also opened thousands of free Wi-Fi hotspots, expanded internet adoption programs, just as Kristen outlined, provided internet service subsidies for students in need, increased internet speeds, distributed thousands of free laptops, forgave millions of dollars in debt, and ensured households stayed online even when they were unable to pay their bills. These steps, all voluntary and without government mandates, have enabled thousands of Massachusetts residents and businesses and families to access vital services such as telemedicine and education online. Lastly, our members have invested billions of dollars in their networks. In 2020 alone, nationally, our members invested $17 billion in their infrastructure. And over the last 20 years, they've invested over $290 billion in those networks. Since then, from 2015 to 2020, broadband prices have fallen 28% and speeds have increased 15% in providers' most popular speed tiers. And lastly, in the fastest speed tiers, speeds have increased 28%, while prices have fallen 44% over that time. I know there was a discussion about 5G earlier. The future in our industry, and that's the wireless industry, in our industry, it's about 10G, 10 gigabit service, which will drive the future for all of us. Combined, our commitment to our consumers and customers is longstanding and clear, and we strongly urge the committee to reject any effort to regulate broadband at the state level, particularly when most likely any of those actions are preempted by federal law. I appreciate your time, and I apologize for going over.
You were a bit over, but you spoke extraordinarily fast. So I understand the complexity of this, and one of the challenges that we have on this committee, and Senator Finegold has talked about this on numerous occasions, is that there needs to be collaboration and knowledge and understanding of what's going on at the federal level as it affects us directly and what we're trying to do here. And that's an added level of complexity that we will be, spending a great deal of time on. So, I appreciate that thought on that complication. It's very real. Okay, thank you very much. Are there any questions on that presentation? Okay, before I circle back again, I would like to see if Rep. Rogers is still with us. Rep, are you still with us?
Yes, I am, and thank you so much for this opportunity. I'm really grateful for the here in front of the committee. So, dear Chair Campbell, Chair Finegold, through you to the members of the committee, I want to congratulate you also on this new committee. It's a really remarkable subject matter that you're dealing with, and I want to testify on a couple bills, H-142 and H-136. H-142 is an act establishing the Massachusetts Information Privacy Act, and H-136 is an act relative to data privacy. Both of these are filed with Representative Vargas, and this really is about surveillance capitalism. We're living through an age when the pace of technological change is far outstripping the ability of policymakers to craft law and regulation to deal with that technological change. We've seen that in the legislature with the facial recognition technology legislation we passed as part of the police reform package when it came to light that facial recognition software was being used in ways that were not regulated really at all. And access to the internet is now not a luxury, it's a necessity. And as more and more people get online, we see where technologies outstrip the law, perhaps in many ways, but perhaps in no other way than the area of personal information, our personal information. Some of you may be familiar with the book Surveillance Capitalism, written by Shoshana Zuboff, and I saw a talk she gave, I think it was a TED Talk. It was pretty remarkable the way she framed it. She compared it to harvesting timber or trees the way they do to make paper. And what she pointed out is that the new business models of large technology companies, they depend on a discovery, an innovation. That discovery is that our private human experiences are the last virgin wood available to be harvested for extraction, production, commodification, and sales. And so, as I put it, we don't search Google, Google searches us. And so what we're seeing, people getting tracked across all the applications they use, biometric information, health information, what zip code you're in, whether you're looking at real estate listings, whether you're looking at car listings, who you know, who you interact with, who your friends are. Vast amounts of data are compiled on us and then used to target us with advertising and in other ways. it is, and look, all around the country in the various state legislatures and now in the Congress, this is a big new area of policy. States and Congress are trying to wrap their arms around. And you're going to hear from some experts today if you haven't already. I guess what I would say, and I'll let your committee and your staff dig into all the details. One of the bills is a 50-page bill. Apologize for that, but it is a complex area. And what the Bill 142 would do is establish the Massachusetts Information Privacy Commission, a state-level commission empowered with various authorities to oversee this broad topic area. It establishes bright line rules for what consent is. Think about these click-through software license terms that we all click on to join various. Who reads them? Nobody. No one. But we want to be on Facebook or we want to be on countless other things. So we just click OK. And so now we've given up various rights and provided these companies with various rights. It makes the bill before you would make much more clear the standards on how they have to protect our personal information, how they can use it, particularly how they might sell it or license it to third parties. And so I think we really need to address this. It's an ongoing problem. Maybe some of you saw The Social Dilemma on Netflix, where what's powerful about that documentary for members of the committee, if you haven't seen it, of course, for the chairs, is rather than outside activists, these are insiders from these companies themselves, Twitter and other large tech companies, talking about what they saw on the inside. So I commend it to you. Again, it's called The Social Dilemma. It's a documentary. So I hope that the committee will look closely at both of the bills I mentioned, because I think we now clearly need to address what is a rampant problem. And I think breaches of privacy that are ongoing, and they need to be addressed. The other thing bill I would mention briefly is H134, again, filed with Rep. Vargas and Act relative providing net neutrality and consumer protection. You just heard from someone opposed to it. I get it. But, you know, the Obama administration proposed a rule. It was adopted. Trump overturned it and got rid of it. And then it was litigated. And interestingly, the federal judge that ruled on this said Trump administration did have power to overturn the Obama-era rule. That was lawful for them to overturn it. However, it specifically held that states do have the power, if they so choose, to regulate net neutrality. That's the law. That is the law. Now, we could speculate whether the Biden administration will implement a new law, but states do have this power. I'm going to be clear about that. And so I appreciate the opportunity to testify. I'm very grateful to the committee, and thank you so much.
Thank you, Rep, for being here. And yes, there's been an awful lot of, I think, valid attention on this particular issue. So we will be having many conversations on this and a number of bills pertaining to this in committee. And it's certainly a lot going on at the federal level as well that we're keeping an eye on as far as it pertains to this issue. So again, thank you for your testimony. Are there any questions at this time from any members of the committee on either of these pieces of legislation? Okay, I am going to circle back again and to see if Lisa Nagy is here. Lisa, are you? So there you are, very patiently waiting. Thank you, Doctor. I apologize. And go ahead, the floor is yours. You need to unmute yourself. Lisa, you're still on mute. Okay. You're still on mute, Lisa.
I keep hitting.
Okay, there you go.
I was saying the little bar is not as easily visible because there's so many participants today, I think. But so thank you very much for getting back to me. I was giving a lecture on Zoom and it ran over. So I'm going to quickly introduce myself, speak quickly, give maybe some credentials and my motivation to support the bill related to children and Wi-Fi in schools and radio frequency radiation in general. I'm a big user of technology now. I'm less sensitive than I used to be. So I am promoting availability of technology to all, obviously, in terms of those other bills. I speak in the media and in Congress and government agency on environmental medicine and environmental illness. And I went to Cornell Medical School and I went to Penn undergrad, and I never heard of really chronic fatigue syndrome, chemical sensitivity, electrical sensitivity, Gulf War illness, and fibromyalgia. They're all in the same basket of diseases. And I feel my forte is speaking quickly about the symptoms. 70% of women over 40 have mild environmental illness. 5% of the population is disabled from it, yet nobody in medicine believes it, especially men in medicine. Women experience it more easily because testosterone is protective, we think. So when people say, I don't like perfume or diesel exhaust or red wine, it's often the women that have that experience. And the male physician thinks that the patient is speaking quickly and refers them to a psychiatrist because it couldn't be that the validity of this patient is true. So when I presented in Congress to the Veterans Health Subcommittee, they appropriated $100 million for toxic exposure research in veterans, and took my information with Wes Ashford from Stanford, who got that funding. I recently spoke to this subject at Stanford and their dysautonomia group on environmental exposure, whether it be Wi-Fi, mold, chemical, leading to damage to the nervous system, and how that makes the heart go fast on standing. And then children in schools are suffering from this big time. They fold their arms and pretzel their legs because the veins are dilated in the legs with postural tachycardia, this dysautonomia. It's now popularized from long hauler syndrome and COVID. They often get POTS, this fast heartbeat. The problem, and the thing that I think is interesting for people, is to understand that kids are becoming tachycardic, anxious, getting panic, and having adrenal dysfunction because of prolonged untreated POTS. So it's a stress. The adrenal gland is the stress gland and pumps out cortisol to cope. When it burns out, these kids crave certain drugs or carbohydrates or alcohol or stimulants that constrict the veins in the legs. So they become addicted to nicotine, caffeine, cocaine, amphetamines, and then eventually heroin for the adrenal insufficiency, as well as donuts and cookies and candy. So what I'm seeing on the Vineyard is a huge proportion of suicide and depression in people living in moldy homes or people in the schools, and they're rebuilding all the schools because of the mold. And if you take a moldy school or a regular school and add Wi-Fi, industrial Wi-Fi, they both are damaging the voltage-gated calcium channel in the membrane of the cell. So you're confounding the environmental, like, toxic load of all the exposures and multiplying the symptoms in some kids who may be genetically have a predisposition, I can't say that word, and nobody really gets why they're sick or what's going on, and they label it again anxiety, psychiatric stuff. And so what I would say, I was supposed to hit the 3-minute thing, so I would know when to stop. But I'm just going to say a few more things. I met Jamie Raskin when he was up here, the impeachment manager, speaking a month ago, and we discussed legislation, bipartisan, on subject matter that would save healthcare billions by getting to the cause of chronic disease, period. He and I discussed Medicare should support taking an environmental history. When did a child start to have the symptom? Did they have Wi-Fi in the school? Am I at 3 minutes already?
Yeah. And you're
okay.
on, Lisa, and I hate to cut you off, but we do have a lot of individuals who are yet to testify.
Okay.
So if you could just, wrap it up, and also request that you send us your written testimony, and that we read, obviously, all written testimony in great detail.
Well, I'll just summarize. In the government agencies, I presented at NIEHS. Linda Birnbaum was the director, and she said environmental medicine shows promise for treating chronic disease. which is really a hallmark sentence. Smart women know these issues are true, and sometimes we don't have time to learn it. So when I'm explaining, look at a video link, it's easier than anything else in a PowerPoint. If I could send it to the committee, maybe that would be helpful for people with interest in this area to see. We can't really afford to make kids sick in school at all.
Lisa, I have to cut you off. Okay. Do send that to us, and the information that you send is available to the committee at large. So thank you very much for your testimony.
Sure, thanks.
I believe at this time we're going to circle back to some privacy related bills. And next on my list, I have Christopher Gilrain. Christopher, are you here? And did I pronounce your name correctly?
I am, and you did, Madam Chair. Thank you.
You're welcome. Please proceed.
Thanks very much. I appreciate your time today. Madam Chair, Chair Finegold, in the interest of time, I'm not going to dive into individual bills, but walk through some of TechNet's key policy principles as they relate to data privacy. TechNet is an industry organization representing about 85 companies throughout the innovation ecosystem. And we have a set of privacy principles that all members agree to at the beginning of every year, that data privacy is consistently the #1 issue on the minds of all of my members. The internet is a global borderless ecosystem. Ultimately, TechNet supports a federal standard that ensures that people in all 50 states have a clear set of rights when they access it. And this is not just something that we say. This is something that we work very hard at. Our federal team is putting a lot of time and resources into pushing a national standard, and they will unveil a pretty major campaign to that effect in the new year. But of course, we're here to talk about state standards. In the absence of a federal standard, we believe that states pursuing their own privacy statutes should consider interoperability with existing models as the default position. And I'll get into kind of what we mean by that. But I recognize that this can be tough for Massachusetts, right? I know we like to break new ground. We like to be in the vanguard of key issues. But we want to consider that each new wrinkle in a privacy law can increase compliance costs and make it more difficult for consumers to understand and access their rights. Relatedly, when considering privacy legislation, we ask that the committee connect specific remedies to specific privacy harms. What we mean by that is a truly effective privacy law is as clear and explicit as possible. It should be clear what is expected of companies, what conduct they are expected to avoid, what their responsibilities are, and what consumers can expect to avail themselves of. The introduction of vague definitions or concepts that introduce subjectivity can lead to accidental or unintentional noncompliance. When you pair that with a private right of action, as is considered in some of these proposed bills, the liability can be ruinous for small and medium-sized businesses that can't afford a full-time staff of compliance attorneys to keep up with the changing requirements and responsibilities. We saw that in Illinois when a cottage industry of class action law firms are making a fortune off of what are oftentimes unintentional or benign violations of the state's Biometric Information Privacy Act. Most times these cases are settled without finding any harm at great cost to businesses and little benefit to anyone but the plaintiff's bar. I recognize that my time is up, and so I intend to send some comprehensive written testimony to the committee. I hope that TechNet and our member companies can be a resource to the committee as you consider these issues.
Thank you very much for doing that within a very small allotted amount of time. And just as a summary point, I think one important issue that you were trying to raise is that when we look at these issues around privacy and data privacy, that we really need to begin with industry-specific research. In other words, to look at the industry as its own, for example, the healthcare industry, right? Being specific and having specific requirements as we proceed. Would that be a correct way to summarize of some of what you're saying?
Yeah, that's certainly a part of it, Madam Chair. Thank you. And yeah, there are certain sectors that are already covered under federal law, and that needs to be taken into account as well. We also, in addition to kind of urging the committee to look at all sectors, we also hope that you'll look at existing privacy models that are already out there, because most of these companies have had to come into compliance. And the last thing that we really want is a patchwork of 50 different standards that would result in uneven distribution of rights as well as severe compliance costs.
Thank you. Are there any questions from committee members on this specific topic? Okay, this incorporates actually a number of bills in the committee, so it is a topic that is going to be looked at very closely. And if from your perspective you have some examples of what certain states might be doing well, please feel free to share those with us.
I appreciate that. Yeah, we will outline that in our written testimony.
Okay, thank you. Next on our list to testify is Susan Grant on Senate 46. Susan, are you still with us?
I am, thank you.
You're welcome.
And I'm also going to testify at another bill. So I'm Susan Grant, Director of Consumer Protection and Privacy at Consumer Federation of America, an association of consumer organizations across the US, including in Massachusetts. CFA strongly supports states' efforts to protect privacy, and I'm personally interested in Massachusetts legislation since I live in the state. I appreciate the opportunity to testify today in support of two bills, S46 and H136. Studies have shown that large majorities of people feel they have little or no control over the data companies collect about them, are concerned about how their data are used, and believe the potential risks outweigh any benefits they get. Most say they have little or no understanding of what companies do with their data and want government regulation. It's not surprising that people are in the dark about companies' privacy policies because the commercial surveillance system is largely invisible. They are stealthily tracked as they visit websites, use apps, and carry their smartphones. Their behavior is analyzed to create profiles about them, augmented by information they provide to create accounts, make purchases, answer questionnaires, etc., and that data brokers supply. These profiles are used to treat them in certain ways, while practices such as targeted advertising, what we call surveillance advertising, may seem innocuous. They can determine who gets shown ads for employment, housing, or credit, and who doesn't, and what prices people see for products and services. These data practices can also be used to promote unhealthy products, encourage excessive gambling, perpetrate fraud, and other purposes that are very concerning. Furthermore, the enormous stores of personal data that are collected put individuals at risk for identity theft and unwarranted government use. S46 and H136 take different approaches to these issues, but both would change the paradigm from one that allows companies to do what they want with personal information as long as they describe it in their privacy policies, which no one reads or understands, to one of privacy by default. The written testimony that I've submitted details the merits of these bills. Massachusetts should enact legislation to prevent people from being forced to trade their privacy for the ability to shop, search for information, enjoy entertainment, find their way, connect to others, get the services they need, and do other things that are integral to their daily lives. Don't let big tech and advertising companies dissuade you with scare tactics, and don't follow other states' bad laws. You can enact the best privacy law in the country, which will be a great thing for Bay Staters and a great example for other states to follow. Thank you.
Thank you very much. Are there any questions, comments from the committee? Okay, thank you very much for your testimony. Next on my list, I have Woodrow Hartzog. Woodrow, are you here? Okay, we will circle back. I next have Anton Van Seventer. Anton, are you here?
Yes, I am here. Thank you, Chair Campbell.
You're welcome.
So my name is Anton, and I'm with the firm DLA Piper, representing the State Privacy and Security Coalition. And we're a coalition of 30 companies across sectors and 7 major trade associations. And we've been involved with the drafting and providing feedback on several of these sort of omnibus state privacy bills in the past. And this has really given us an opportunity to compare and contrast some of the the fine-toothed comb elements of many of these bills. And, as Chris brought up, we recognize that bills like this are well-intentioned, specifically, and I'm thinking of bills like S46, for example. But unfortunately, the bills that we're seeing, specifically this one, is perhaps the most extreme and unworkable privacy bill our coalition has seen throughout the states. And it's simply because it includes these specific sort of outlier requirements that impose major compliance burdens on businesses and often actually harm consumers to the point that we've even seen consumer groups oppose some of these provisions. So I just wanted to give some specific examples to sort of illustrate the complexity that we often end up dealing within these bills, and that it doesn't need to be a business versus consumer frame of reference. That bill, for example, S46, uses a double opt-in consent framework, which means that consumers are effectively required to opt in multiple times and then continuously opt in order to get services that they've frankly become accustomed to over the last several years. And this unending notice fatigue is coupled with an onerous cost to businesses that really exceeds the way that this bill is written, even the GDPR and the CCPA, which are known as some of the more aggressive privacy bills in the space. These requirements would even force businesses to invalidate a consumer's freely given consent if the confusing set of additional opt-in requirements are not met. And so I just want to make the point that again, this is not a pro-consumer requirement, and that these issues there's often more gray area and complexity than they at first appear. The bill would also require businesses to respond to an access request by a consumer with a specific list of third parties. And this is actually technically impossible at the moment. We just don't have the tracking technology to be able to effectuate this. The final point I'd like to make in regard to that bill, and we'll be submitting written testimony on that and S50 as well, which we believe is more of a mixed bag, actually. There's a private right of action in the bill as well as a class action in regard to the Unfair and Deceptive Practices Act statute. And this has been shown in California, and for this reason, no other state has followed this path, to really just create opportunities for the plaintiff's bar and for trial lawyers to inflict highly asymmetrical e-discovery costs on these businesses. And the cost to defend these is often $500,000 for businesses, but very little for the plaintiff's firm. So again, I just wanted to make the point that these provisions like this don't often benefit consumers. They often either create confusion or benefit the plaintiff's bar. And we just encourage the committee to go through these with a fine-tooth comb as we move forward in comprehensive privacy legislation. Thank you so much for your time.
You're welcome. A lot of info in a short time. Are there any questions from the committee? Okay, hearing none. I am going to call on Katrona Fitzgerald. Are you here?
Hi.
That's
Yes,
actually
hi.
Katrina Fitzgerald. So I want to make sure we get this right. She's, we think very highly of her on the land of Finegold Camp. So, Katrina Fitzgerald.
Thank you, Chairman Feingold. Proud former member of Team Finegold. Thank you, Chairman Finegold, Chairman Campbell, and members of the committee. My name is Katrina Fitzgerald. I'm Deputy Director of the Electronic Privacy Information Center, or EPIC. EPIC was founded over 25 years ago to focus public attention on emerging privacy and civil liberties issues. And although EPIC is based in Washington, D.C., I'm a Wakefield resident. My testimony will largely be in support of Senate Bill 46 and House Bills 142 and 136, which are the comprehensive privacy bills, but I also want to express strong support for Senate Bill 50, Chairman Feingold's bill to create a data broker registry. The shadowy data broker industry is in urgent need of transparency, and I would urge you to give the bill a favorable report. But back to the comprehensive privacy bills. I just want to take a minute to talk about why Massachusetts should enact a strong privacy law. Despite technology's prevalence in our lives and our economy, there really is very little regulation in the US about what data companies can collect about us and how they use it. And that's created an online ecosystem where large digital platforms are commodifying every tiny bit of our data. And that has real harms, especially for marginalized communities. We've all had the experience of being creeped out by an ad targeted at us. Many people actually assume that companies like Facebook must be using the microphones on our phones to listen to us because the ads are so creepy. They're not listening to us, but the reality is even creepier. They don't need to hear us to know what we're saying or thinking because that's how much data they're collecting about us. The websites we visit, where we're going, who our friends are, what those friends are reading or doing. They're tracking so many data points about us that it really seems like they're listening to us. Now, for some people, that means being creeped out by an ad, but for marginalized communities, it can often mean not being shown an ad for housing or job openings, and that deprives individuals of life opportunities. So, this system of self-regulation we've been operating under, clearly not working. Since Congress is showing no signs of action on privacy, despite years of discussion about it, state legislatures really need to act, and Massachusetts has an opportunity to be a real national leader here. Obviously, this is a difficult issue. There's a lot of fine points about it, but I'll make two quick broad points for you to think about as you craft privacy legislation. One is that privacy laws should set limits on the amount of data companies can collect about us. It's not enough to say that individuals have a right to know what companies are collecting. That's not that helpful. It's time to limit what they can collect. And the other point is enforcement. We've seen it with other states. Without strong enforcement, you may as well not pass a privacy law. It's critically important to include both strong state enforcement mechanisms, such as the state agency proposed in these bills, as well as a private right of action. And the last thing I'll say is that committee members should be skeptical of industry groups urging you to mimic current state privacy laws. The reason they want you to do that is because the state laws that have already been passed are not very good. They don't do much for privacy. They allow the harmful business models of tech platforms to just carry on. Virginia's law was written by Amazon and Microsoft. California's law was rushed to avoid a ballot question. Massachusetts can do better. So I'll submit written testimony, but I'm happy to be a resource for the committee as it addresses this urgent issue. Thank you.
Katrina, thank you very much. And I do have one quick question, and it's request for some more information. Sure. So it would be really helpful to the committee if you could let us know in some written testimony or some conversation about, those that say that we're going to run into so many federal entanglements that we should just kind of throw our hands up, right? And you alluded to that a bit, but that is something we definitely need some more information on as to how to avoid that and how to answer that question as we move forward on this issue. And that would be really appreciated.
Absolutely. States have acted on privacy for a long time. There's a lot of sector-specific privacy laws that states have passed, and I'm happy to provide information in written testimony about that.
Super. Thank you very much. Only the good ones, though, that you see some perspective, as you mentioned. Thank you very much. Any questions for Katrina? Okay, hearing none.
Well, Madam Chair, if I could just really quickly, thank you, Katrina. Just quick, you referenced the importance of limiting what they can collect. Is that groundbreaking? Is there a model? Is anyone else doing it? Can you shed a bit more light, like in, I don't know, Chair Campbell, 15 seconds?
Sure. So it's a concept called data minimization. The idea is that companies shouldn't be collecting more data than me as the consumer expects them to collect, right? So if I buy something, I expect the company to collect my address and my payment information and my email. I don't expect them to collect, 10 other data points about me. So that's kind of the concept behind that. And there's legislative language around that I'd be happy to share with the committee.
Great, thank you.
Yeah, that's very helpful. We get to stage 5 when we're buying something and they ask us for our life history. We experienced that in great detail. So thank you. We appreciate and look forward to more conversations. Very much so.
Thank you. Thank you, likewise.
I believe we've been joined by Senator Crean. Senator, welcome. And if you would like to speak, please go forth.
Thank you very much. Thank you, Chair Campbell and Chair Finegold, for this opportunity to testify. I'm very glad that I went after Courtney because I found her presentation was exceptional. And I'm also here to speak in support of Senate 46, the Massachusetts Information Privacy Act. In our increasingly digital world, your personal data is a ripe source for business to harvest for their own interests. From Google to Facebook, the companies that we rely on for the services that make the internet useful and interesting are tracking our every move and seeking to learn as much about us as possible, certainly more than we want them to know. As people learn more about big companies and data brokers are using our personal information, we seek more control. Currently, individuals have little power to access, delete, or prevent the sale of our data. We practically have no power. We need more rights to control our personal data and how it is used by third parties. This legislation, known as the Massachusetts Information Privacy Act, would protect our personal information by regulating the use and sale of personal data by business and data brokers. The bill would protect sensitive personal information from being collected, used, or monetized without consent. It would prohibit discrimination based on information they receive. It would protect sensitive personal information from being collected. The MIPA ensures that an individual's biometric information, such as facial images or fingerprints, can't be collected without permission. And notably, this bill would create a new commission on information privacy with authority to issue regulations on individual privacy rights and enforcement powers to respond to the violations of NEPA's provisions. The federal regulators who are supposed to be looking out for our privacy are not doing enough, and I don't know how much at this point, to protect our personal digital information. Fortunately, we live in Massachusetts, and we have the opportunity to do more to protect privacy. After all, Massachusetts has often led the way. I think we should keep up to that. And in the complicated world of internet privacy, we as legislators have a role to play into protecting the data of consumers. After all, individuals should be treated as their owner of their own data. Now is the time to step up to the plate. Thank you very much. I'm happy to answer any questions and appreciate the opportunity to be here.
Thank you, Senator. Are there any questions from the committee? Well, thank you, Senator. We look forward to continued work on this topic, and we thank you for your time today.
Thank you.
Welcome. I believe we now have a panel, and I am sure to massacre these names, so please do correct me. We have Amelia Falcon Morano, and maybe I'm close, and Cade Crawford.
Yes, hi.
Okay, well, thank you for being with us. The floor is yours for about 3 minutes.
All right, fantastic. So I'll start. Good afternoon, chairs, members of the committee. My name is Cade Crockford. I'm the director of the Technology for Liberty program at the ACLU. I'm joined by my colleague Emiliano Falcon Morano, who's going to speak to you shortly. Emiliano and I are very excited to be here today on behalf of the ACLU and our nearly 100,000 members and supporters statewide to testify in strong support of the Massachusetts Information Privacy Act, which we're going to call MIPA. That is House 142 and Senate 46. We also support House 136 filed by Representative Rogers and Senate 50 filed by Chair Finegold. We're heartened to see so much interest in digital privacy this session, and we look forward to continued collaboration with this committee, lawmakers here, residents, and advocacy partners to make sure Massachusetts takes strong action to protect the public interest in this area. And doing so, as you've heard from others, is an urgent necessity. After all, every single one of us leaves behind a trail of data that reveals nearly everything there is to know about us: our interests, political preferences, health conditions, social networks, deepest fears, greatest desires, and so much more. We use the internet to find love, work, housing, fellowship, education, and to get from point A to point B. It is a central part of our lives. Despite the centrality of the internet, people in Massachusetts, as Senator Cream said, have essentially no control over how companies use the information that we generate online. Companies today can use big data to discriminate against us. For example, researchers found that users of ride-hailing apps in Chicago were charged higher fares when they took trips to or from Black and brown neighborhoods. There are other dangers. A few years ago, you probably remember, the Cambridge Analytica scandal showed us our online data can be used not just to sell us shoes, but also to try to sell us authoritarian politics. Now, researchers are divided on the question of whether or not the Trump campaign's digital manipulations in fact tipped the election results, but there's no doubt that big data manipulations can have a huge impact on a person's choices. Take, for example, a case in Massachusetts where a digital ad buyer used geolocational targeting to serve ads to people in the vicinity of Planned Parenthood offices, and not just any ads. These ads encouraged people to seek healthcare at anti-abortion, quote unquote, family planning centers. And likewise, in Philadelphia, patients waiting at an ER were targeted with ads for personal injury lawyers. So losing control over one's personal information can be a shattering event. For example, users of the gay dating app Grindr were shocked to learn in 2018 that that company was sharing their HIV status and other extremely sensitive personal information with third parties. So the lack of regulation harms all of us, not just sexual minorities, not just people seeking medical care. According to reports, this is astonishing, there is a $12 billion industry exclusively dedicated to selling and trading our cell phone location data. And a journalist working for Vice, looking into this industry, was able to pay a bounty hunter $300 and in return received real-time cell phone location information for his own cell phone. Obviously, the existence of a market like this threatens every single person's personal autonomy and even safety. And Massachusetts residents should not fear that using a cell phone will subject them to invasive, shadowy surveillance, enabling untold numbers of people across the world to track their every single movement in real time and historically. The only way to address problems like the ones I have described and many others is through the law. And so I'm very happy to turn to my colleague Emiliano, who's going to describe how MIPA works and what it seeks to accomplish. Thank you so much.
Thank you very
Thanks,
much.
Kate. Thanks, Chair. Thanks, Kate. Good afternoon. My name is Emiliano Falco Morano. I am the Policy Counsel for the Technology for Liberty program at the ACLU of Massachusetts. MIPA is a major legislative package that draws on lessons learned from significant privacy laws enacted in other jurisdictions, including Europe, California, and Illinois, with the goal of establishing the Commonwealth as a leader in the field of data privacy. I want to provide a general overview of 4 important aspects of this bill. Together, these provisions will enable us to exercise control over our personal information for the first time in this digital era. First, the bill goes beyond the typical de facto notice and consent framework that alone completely fails to protect privacy. I'm sure you've clicked I agree thousands of times to access a website or an application, and I'm confident that you didn't once read one of those agreements. And if you did read it, it was hard to get through, confusing, and certainly did not build a trust relationship with the company collecting your data. MIPA addresses this click-to-agree problem in two ways. First, by creating meaningful notice and opt-in consent requirements that consider how privacy fatigue affects individuals. And second, by shifting the burden to corporations, establishing that they owe the duties of care, loyalty, and confidentiality to their users when collecting and processing their personal information. The second important aspect of MIPA is that it protects against so-called black box discrimination. Black box discrimination is when companies use secret and complex algorithms that result in different treatment for different groups of people. Kate provided the example of the research in the city of Chicago that showed discrimination in pricing algorithms used by ride-hailing companies. So to address these and similar harms, the bill prohibits companies from processing personal information in a way that would discriminate against individuals that belong to protected classes when advertising, offering products and services, and providing access to public accommodations. Third, MIPA bans the practice of selling and trading especially sensitive types of information, namely location information and biometric data. And to make sure that companies never collect a person's biometric data without their consent, the bill requires that a company obtain specialized, discrete, express consent for collecting biometric information. Location and biometric data are especially risky and dangerous, and MIPA treats them accordingly. Finally, MIPA is serious about enforcement. Privacy law has to be very serious about enforcement, so MIPA adopts a two-pronged approach. First, the creation of a new agency empowered to levy civil administrative penalties and a private right of action. I want to note here that both penalties and court awards provided by MIPA are expressed in dollar figures and in percentages of revenue so that they impact all businesses, small or large, in an equitable way. This will ensure both an avenue for redress from data privacy harms and deterrence of bad practice, as private enforcement of antitrust law shows. All in all, MIPA is a complete...
Wrap up. Good.
Yeah, thank you. Sorry, Chair, I'm wrapping up. MIPA is a complete package of data privacy protections. If it is enacted, this landmark bill will protect Massachusetts residents and establish the Commonwealth as a global leader in information privacy. Thank you very much.
Thank you. Are there any questions, comments from committee members? Okay, thank you very much. I'm just going to remind everyone moving forward to keep your testimony to 3 minutes or under 3 minutes, and we will ensure that we were able to speak with you additionally following the hearing, if need be.
Yeah, and just to echo what Chairwoman Campbell saying, we still have a very long list, and it's not fair to the people that still have to testify. And like I said, we actually, all our staff, we read everything you send us. So if you're not able to get everything you want to say, the written word is also just as powerful.
Thank you. I second that again. Ryan Kearney, are you still with us?
I am, Madam Chair. Thank you.
You're welcome.
Chair Campbell, Chair Finegold, members of the committee. First, my name is Ryan Kearney. I'm General Counsel of the Retailers Association of Massachusetts. And RAM would like to be recorded in opposition to Senate 46, an act establishing Massachusetts Information Privacy Act, as well as its House counterpart, as these bills would impose costly and unworkable requirements on retail businesses, interfere with their ability to provide customer services, and unnecessarily expose businesses to significant legal liability. The collection of consumer data is an essential part of any retail business. It's utilized in conducting sales transactions, deliveries and returns, detection of fraud, loyalty programs, the list goes on. And in each one of these instances, the data provided by the customer allows for more efficient business operations and more positive customer experience. Simply stated, retailers are utilizing consumer data for the principal purpose of excuse me, of serving their customers as they wish to be served. And the costs, obligations, and potential liability created by this legislation, it is our fear that that'll interfere with the ability of retailers to continue to serve customers in this manner. First, I just want to touch on cost. The general provisions of the legislation will require significant investment. It's policy changes, technologically investments, staff training, staff hiring to deal with this type of compliance issues. And the member feedback from our membership is that the cost of compliance is estimated to be about $1 billion just to invest, and that does not guarantee that you are going to be in compliance. That leads me to our second issue, which is the exposure to liability, which is a major concern to our industry. The statutory damages alone provided in this legislation could quickly add up to an award that would be financially ruinous for most businesses. Also, we're unclear as to why there is a need for 3 avenues for enforcement. With the creation of a new enforcement agency in particular, it seems that a private right of action is unnecessary. RAM strongly opposes the inclusions of a private right of action, particularly one that allows for limitless relief, lacks for restriction of the type of violations eligible for such actions, lacks a cure for alleged violations, and lacks the requirement that a violation result in actual harm. In terms of scope, the statutory obligations imposed by this bill should apply equitably to similarly situated entities that handle consumer data. RAM cautions against the committee against endorsing any exemptions to comprehensive obligations.
Can I stop you there? You're over time. I just wanted to stop you there and ask you to wrap up quickly if you could.
Sure. Just in closing, it's been said before, RAM believes the regulation of consumer data is a federal issue and should remain a federal issue. The reality of today's economy allows for folks to go across state lines regularly via the internet. The hope is that through a federal law, we would have a uniform regulation that allows for an ease of compliance for interstate operators and also creates a uniform set of protections for our consumers. For these reasons, we ask that RAM respectfully that the committee oppose Senate 46.
Thank you. Thank you for wrapping up there. Are there any questions from committee members on this testimony regarding Senate 46? Okay. Next on our list is Irene Tung. Irene, are you still with us? Okay. Next is Pablo. Pablo, I'm going to mispronounce your name, so if you are there, please do so for us. If you're still.
I'm here. That was a good one on my name. So thank you very, very much for having me. It's truly an honor to be here. Dear Senator Finegold, Representative Campbell, and members of the committee, I'm speaking actually in support of H142 and S46. So, and I respectfully ask this committee to favorably report this legislation, which provides critical privacy and non-discrimination protections that currently do not exist in state law. My name is Pablo Boczkowski. My broad area of expertise is the study of the evolution of digital culture and its implications for media, society, and politics, including issues of privacy. I currently work at Northwestern University, where I am the Hamad bin Khalifa Al Thani Professor in the Department of Communication Studies. Before coming here, I was on the faculty at MIT, and both of my daughters are proud Bostonians. So it's good to be back, even if only virtually. Today, corporations collect, process, store, and disclose unprecedented quantities of often sensitive, granular information about every one of us. These data are also used to conduct secretive digital discrimination, and despite quantum leaps in computing power, the growing use of artificial intelligence to process information, and the ever-increasing number of companies that trade and sell personal information, consumer privacy law in Massachusetts and in the US has not been substantially improved in decades. In the book, The Digital Environment, How We Live, Learn, Work, and Play Now, published by the MIT Press in August of this year, my co-author Eugenia Michelstein and I argue that the main consequences of the rise of the digital in the contemporary world is that it has become an environment rather than a series of discrete technologies, an environment that envelops and shapes virtually all major facets of everyday life. We further suggest that therefore people live in 3 coexisting environments, the natural one, the urban one, and the digital. But While the first two have existed for a long time, the third one is still new and rapidly evolving. Therefore, the relative novelty of the digital environment makes the opportunities for contemporary actors to transform applications, devices, and infrastructures greater now than what it will probably be the case in a few decades. Therefore, now is the time that we can create the kinds of relations and infrastructures that will contribute towards a more diverse, equitable, and inclusive digital environment. This greater window of opportunity to act towards creating a better digital environment includes issues of data and information privacy. The Massachusetts Information Privacy Act provides a comprehensive privacy framework that dramatically changes the privacy law landscape in the states. The bill creates a very comprehensive regime that provides several rights to individuals and imposes fiduciary duties on companies. The approach considers the best parts of laws from other states and jurisdictions, including those enacted in California, my current home state of Illinois, and the European Union. On the one hand, the bill enshrines the traditional privacy rights of access, correction, and data portability, and on the other hand,
you can start to wrap up.
Okay. The bill imposes duties of care, loyalty, and confidentiality on the companies that collect and process our information. For these reasons and many others, I respectfully ask that you favorably report this crucial legislation. Thank you once again for your consideration.
Thank you. Are there any questions from the committee for Pablo? Okay, thank you very much for your testimony.
You're very welcome. Have a great day.
Yeah. Next, we, I believe, have a panel of Baba Nunnery and Lindsay. Are you here with us?
Absolutely. Can you hear me okay?
We can.
Okay, great. So hi, everyone, committee members, respective chairs and vice chairs. My name is Baba Nunnery. I'm the Senior Director of Privacy and Public Policy at ZoomInfo. I'm joined by my colleague and Senior Policy Analyst, Lindsay Stewart. So happy to be here. Thanks for having us. We'll also be addressing Senate Bill 46 and House Bill 142. I will say our understanding was that testifying as a panel would give us a little more time. We're definitely hearing what you guys are saying. We've shortened what we have to say, and we're going to get through it quickly. Just to give you a little bit of background about ZoomInfo, we're a software and data intelligence company that provides our customers a database of information about companies and about business professionals. We are a global company, but our largest office is located right in Waltham, where we employ more than 800 people. I should also mention that we have more than 1,300 state-based businesses that use our platform. So we're very proud of our connection to Massachusetts. We also fully support the need to protect and regulate consumer privacy rights in the Commonwealth. We believe that data sensitivity is real, but also that regulation should be proportionate to the type of data being collected and the potential risk that it poses to a consumer.
Absolutely. So thank you for having us here. So the reason we're here today and the purpose of our testimony specifically is to urge you that business contact information, which isn't sensitive in nature, but is critical to the economy, not be included in data privacy laws that are really intended to protect consumer data. The information that we're referring to when we say business contact information is what you typically find on a business card: your company, your position, your business email address, your business phone number. Again, this information isn't sensitive, nor is it intended to be private. In fact, it's quite the opposite. If you think about it, tens of millions of business professionals share this information every day. They pass out business cards, they include it in their email signature line, and they post it on professional networking sites like LinkedIn. I think this is a really interesting fact, a really interesting point here. There are 50 million more professionals who intentionally publicize their information on LinkedIn than there are employed US adults in the United States. So again, that's 180 million people who have chosen to make their business information public. Inadvertently relating this information can have huge unintended consequences on the economy. Business-to-business transactions represent $26 trillion annually in the United States. That's nearly twice of all consumer spending. So it's just really important that we don't create any unnecessary friction in our economy by disrupting companies' access to vital information.
I think one of the challenges is that despite it being an enormous part of the economy, business-to-business sales can be something that people don't see or give much thought to. And it's because businesses that sell to businesses don't go to market the same way businesses do that sell to consumers. For example, if my company does corporate training video.
Right there, okay. I'll just stop you right there. You've already spoken, so I'm just going to leave it at that, if you would, just to allow for any questions that the committee members might have. Any questions?
Yeah, well, I would just say that I'm happy, I think we are, if you want to continue this conversation offline, we definitely appreciate your impact here in the Commonwealth. We also appreciate your perspective. So my suggestion is to reach out to our staff and let's continue this conversation because we are very interested in what you have to say. We're also very interested in your perspective, and we don't take lightly that you know, you do have such a huge presence, and is fascinating to know that there are really more people on LinkedIn than there are actually people employed. So that's fascinating. So we definitely love to.
We will, and we've submitted written testimony along with some amendment language in an appendix. So thank you so much.
Well, thank you very much. We will be circling back for questions. There is absolutely no doubt, and appreciate you taking the time to be with us. And I'd like to second that comment from my co-chair about LinkedIn. I think we all just learned something here, very important. But very much appreciate that, and we will be circling back. And thank you for you know, limiting your time. It's
Chair.
Okay. Thank you. Questions for the committee? Okay. Moving on. I have next on our testimony list Erica, excuse me, I apologize. Is Erica here? Okay. John Olson.
I'm sorry, I'm here.
Okay, Erica. The floor is yours.
Sure. Okay. Thank you so much. So dear Senator Finegold, Representative Campbell, and members of the committee, my name is Erica Dara, and I'm speaking on behalf of Fight for the Future in support of both data privacy and net neutrality. We respectfully ask this committee to favorably report H142 and S46 regarding establishment of the Massachusetts Information Privacy Act, as well as S48 regarding the implementation of net neutrality protections in the Commonwealth. Fight for the Future is a digital rights organization based in Boston with over 3 million members nationwide, including over 61,000 members in Massachusetts. Among other focuses, we are a leader in the fight for net neutrality and strong advocates for data privacy. Net neutrality ensures that ISPs cannot censor, block, or throttle certain websites. It guards against censorship and codifies the notion that all data must be treated equally. Net neutrality ensures that ISPs cannot be coerced by politicians, corporations, or public pressure to censor websites, including those related to political or social movements. S48 comprehensively protects marginalized people and websites by carefully translating the FCC's 2015 Open Internet Order into state law. Implementing net neutrality in Massachusetts could inspire other states to take action and encourage President Biden to appoint a 5th commissioner to the FCC so that federal policy could potentially progress as well. Fight for the Future also supports the establishment of the Massachusetts Information Privacy Act. The consequences of mass unregulated data collection go beyond data breaches, product advertising, and invasive surveillance. In the recent congressional hearing with Facebook whistleblower Frances Hagen, algorithmic manipulation was cited as the root of the platform's ability to influence users' feelings, beliefs, and in some cases, their behavior. Personal data is used to fuel these very same surveillance-driven algorithms. Facebook uses intimate information about us to amplify or suppress content in order to keep users on the platform and maximize advertising revenue. Facebook pursues profit despite the harm it knows it causes, but data privacy laws can cut off the fuel supply for Facebook's destructive business model. Further, biometric data collection in particular poses a serious threat to personal privacy and autonomy. Lack of data privacy regulation has allowed technology like facial recognition to proliferate, threatening civil liberties and increasing risk of harm for marginalized communities. MIPA creates a framework that blends notice and consent and information fiduciary models. This creates a comprehensive regime that provides several rights to individuals and imposes fiduciary duties on companies. Among other provisions, the legislation bans companies from sharing or selling location data, including with the government, absent of a warrant, prohibits companies from collecting and using biometric data without handwritten informed consent, and prohibits companies from threatening or mandating an individual's consent or asking questions or providing information in a way individuals cannot reasonably understand. For these reasons and others, we respectfully ask the committee to favorably report on MIPA, as well as legislation related to implementing net neutrality protections. Thank you for your attention and consideration.
Thank you, Erica. You sped through that, but we heard it all and really appreciate and your advocacy group as well. We look forward to keeping in touch as we move through these bills. Are there any questions from the committee? Questions, concerns from the committee? Okay. Thank you very much, Erica. Is John Olson still with us?
Yes, I'm here.
Oh, John, thank you. The floor is yours for 3 minutes.
Yes, thank you, Chair Campbell, and thank you, Chair Finegold, members of the committee. My name is John Olson, and I am the interim head of state government affairs for the Internet Association, or IA. IA is the only trade association that exclusively represents leading global internet companies on matters of public policy. Our mission is to foster innovation, promote economic growth, and empower people through the free and open internet. IA member companies are supportive of privacy frameworks that provide individuals meaningful control over their data across all industries, hold companies accountable, and include purposeful and balanced enforcement. In my written testimony, I note IA's opposition to specific legislation. For the record, these bills are S46, S220, H136, and H142. While IA has long supported comprehensive federal privacy legislation as the best way to resolve consumer privacy concerns, I would like to highlight 5 top-level themes for the committee and sponsors to consider when drafting legislation. Uniformity across state privacy proposals. IA member companies have continually encouraged state legislators to seek uniformity amongst the terms and requirements of their privacy proposals that harmonize across state lines and that can be addressed by one compliance plan. Structure and ease of understanding. Legislation should be clearly written to be understood by the common consumer, not just legal experts. We would strongly recommend following the model adopted by the Virginia Consumer Data Protection Act that utilizes a controller-processor distinction and clear sections indicating the scope of law, clear consumer rights, controller and processor obligations, and exceptions and exemptions to the requirements of the law. Rulemaking and the interpretation of statute by state agencies and attorneys general. IA would recommend that promulgated regulations associated with these proposals be narrowly tailored in scope to technical clarifications regarding the law itself, and enacting legislation require the regulations to be introduced at least 1 year prior to the law becoming effective. Method of consumer consent. We would encourage drafters to consider legislation that adopts a privacy notice and opt-out method for receiving consumer consent. And finally, aging enforcement and a right to cure. Exclusive aging enforcement allows an experienced entity to oversee businesses' adherence with the law and allows better identification of bad actors in the data privacy space. A right to cure provides businesses with an incentive to swiftly resolve consumers' concerns about their personal information and further establish consumer trust with the business. We would strongly recommend not including a private right of action in legislation. I appreciate the opportunity to testify today, and I welcome any questions you may have. Thank you.
Thank you very much, John. Appreciate the concise presentation. It would be helpful maybe if you could send the committee that Virginia law that you felt we might want to take a look at. That would be very helpful.
Absolutely happy to.
Are there any questions for John from the committee? Okay, again, thank you very much for your testimony.
Thank you.
Next on my list, I have Evan Enzer. Evan, are you still with us?
Hello, I'm here.
Evan, the floor is yours.
Hello, Senator Finegold, Representative Campbell, and members of the committee. My name is Evan Enzer. I'm a legal fellow at Surveillance Technology Oversight Project, or STOP, a community-centered privacy and civil rights group that advocates for policy change at the state and local level. Thank you for the opportunity to testify in support of H142 and S46, the Massachusetts Information Privacy Act, or MEPA. MEPA creates a strong consumer privacy program, limits corporations' ability to collect biometric and location data, and provides critical worker protections. STOP believe MEPA is actually a compromise on many points. Massachusetts should ban workplace and biometric surveillance entirely, but it is an excellent starting point. For that reason, I respectfully ask this committee to report this legislation favorably. Major corporations collect an unprecedented amount of granular information about every one of us. Facial recognition identifies us in stores, software monitors our activity, and websites track what we watch, listen to, and like. Moreover, companies are using tracking technology to exploit workers. Cameras and wearable monitors track warehouse workers' every move, and similarly with delivery drivers. The technology drives inhuman work rates, disciplining workers when they inevitably cannot keep up. Corporations also share our personal data with the government. Surveillance-driven policing entrenches racial bias and tech washes discrimination under the guise of objectivity. And on the rare occasions that courts stop the government from taking the data, corporations can simply buy it on the open market. Last year, we learned that data brokers sold location data collected from more than 90 million users of popular Muslim prayer apps to the US military. MEPA's core is a set of consumer privacy protections. Importantly, it prohibits corporations from sharing biometric or location information with the government absent written consent to the disclosure, a warrant, or a federal legal requirement. We believe Massachusetts should ban biometric surveillance completely, but MIPA is a strong start. MIPA goes beyond consumer privacy to grant specific workplace protections. The bill allows workplace surveillance for 5 enumerated reasons. The reasons are actually fairly broad, but the bill only permits monitoring that's necessary, least intrusive means possible, and does not adversely impact physical or mental health. Finally, MIPA prohibits employers from using data to make employment decisions without any corroborating information and without allowing the worker to correct or explain the data.
Thank you.
MIPA enacts consumer privacy rules to protect Massachusetts residents from intrusive corporate practices, limits government access to personal data, and provides key protections for workers. For these reasons, I respectfully ask you to favorably report this legislation. That was a lot to get through.
Yes,
They
it
did a
was.
great job, Evan. We're right to it. So
You were very close. Thank you very much, Evan. Are there any questions from the committee on Evan's testimony? Okay, thank you. Thank you very much.
Thank you so much.
You're welcome. Next on my list, I have Haley Tsukayam. Haley, did I get anywhere close, and are you still there?
I am still here, and you did a fine job, so thank you. Hello, my name is Haley Tsukayama. I'm from the Electronic Frontier Foundation, and I respectfully request that you give H142 and S46 a favorable report. EFF is a 30-year-old nonprofit supported by 35,000 dues-paying members, including in Massachusetts, and dedicated to protecting digital rights in the internet age, including privacy. These bills set a framework that pulls from some of the best practices to protect people that we've seen in other states and across the world. They respond to the needs of consumers and not the desires of companies that have repeatedly shown they will not hesitate to abuse our privacy. In addition to providing the people of Massachusetts with important transparency and education tools, such as the right to access, correct, transfer, and delete what information is being collected about them, and ensuring that people have the right to say from the beginning whether and how their information is being used, they also go directly after some of the worst data practices that coerce people, particularly those in already vulnerable populations, into giving up their information. These bills also set up real consequences for businesses that do not respect people's privacy. Too often we have seen states, such as Virginia, consider bills that have no teeth, making them little more than empty promises or privacy theater. I'd really like to thank Senator Cream and Representative Vargas for recognizing that strong enforcement is the key to meaningful privacy legislation, including provisions for both government and individual privacy enforcement through a commission and through the private right of action, provides consumers meaningful tools to hold companies to account for violating their privacy without having to rely on a regulator. We also applaud these bills for not adopting consumer hostile provisions enacted in other states, such as the right to cure, which gives businesses a free pass to violate the law and sets up the wrong incentives for compliance. By moving these bills forward, this legislature would make Massachusetts a leader in setting a consumer protective framework that centers the needs of people rather than the needs of businesses, and provides people with the tools to protect themselves from companies that consume and process our information in ways we don't expect and don't want. Respect for consumers' wishes should be the cost of doing business with our data, and it has not been, and you can change that. So thank you for the opportunity to testify today and to submit written testimony, which I will do, and I respectfully request again that you give these bills a favorable report. Thank you.
Thank you very much. And thank you for providing the written testimony and also information to contact the organization that you're associated with. That would be very helpful as well if we have questions moving forward. Are there any questions at this time from the committee? Okay, hearing none, I am going to call on Cynthia Koo from the Center on Privacy and Technology at Georgetown Law. Cynthia, are you still with us? Cynthia, you are muted if you're still there. I can see you, but I can't hear you.
Oh, apologies. Can you hear me now?
The floor is yours for 3 minutes.
Excellent, thank you. Good afternoon, Senator Finegold, Representative Campbell, and members of the committee. My name is Cynthia Pu, and I'm an associate at the Center on Privacy and Technology at Georgetown Law, responsible for our work on commercial data practices and worker surveillance. I'm testifying in support of H142 and S46, an act to establish the Massachusetts Information Privacy Act. I respectfully ask the committee to favorably report this legislation, which provides critical privacy, worker, and civil rights protections. I will make 3 points today on their importance, and my written statement will provide elaboration. First, Vulnerable populations need and deserve protection from digital discrimination. Thanks to the far-reaching impacts of online platforms and algorithmic sorting, privacy rights are civil rights. This summer, 24 organizations sent a letter to the Federal Trade Commission identifying no less than 27 distinct harms resulting from wrongful commercial data practices, many of which violate the right to equal opportunity. If a landlord, employer, bank, or university can't reject someone on the basis of race, gender, disability, or other protected characteristics offline, they should not be able to do so online. Yet, under the current state of affairs, they can and do. Second, restricting workplace surveillance and certain uses of worker data is essential to worker safety and their fundamental rights. Invasive electronic monitoring of workers has sobering consequences. In 2019, an Amazon warehouse in Fall Rivers, Massachusetts, accumulated 3 times the industry standard of workplace injuries. This is what happens when you combine punishing quotas, ubiquitous worker surveillance, and the ability to use the resulting data against them. Workplace surveillance also encroaches on the freedom of speech and freedom of assembly because monitored workers are more likely to self-censor or refrain from lawful gathering or legally protected organizing. Third, the law must take into account power imbalances and information asymmetry between consumers, workers, and regulators on one hand, and behemoth multinational technology corporations, which know everything about all of us, on the other. Duties of care, loyalty, and confidentiality protect people from unfair uses of data that they're forced to give up when they depend on companies for political participation, community belonging, or employment. Where harm still occurs, a private right of action enables legal redress that might not otherwise exist. Victims of data harms also deserve access to justice through the courts. Finally, the creation of a privacy commission would build within state government the internal technology, privacy, and civil rights expertise and capacity needed to rein in technology companies and their widespread repercussions. I greatly appreciate the committee's attention to these critical issues, and thank you for the opportunity to present this testimony.
Cynthia, thank you so much. You presented that in a very concise manner, but I think more importantly, you presented in layman's terms, which I think that many could understand, and that's very much appreciated. I believe you said that you provided us with some written testimony.
I will be providing you with a written statement, which will be much expanded on my oral testimony.
Okay, well, thank you so very much, and appreciate the time that you took today and your expertise. Okay. Are there any members from any committee members that have any questions or points they'd like to raise? Okay. The next individual I have on our list to testify is Eric Null. Eric, are you still with us? Okay, we'll circle back. Adrian Clates. Adrian, are you still with us?
Yes, I am. Oh, hold on. Why isn't this working?
Okay, you're here. Thank you for your patience. The floor is yours for 3 minutes.
There we go. Okay, I think I got it working. Good afternoon. Thank you for the opportunity to testify. My name is Adrian. I'm 16 years old and representing Encode Justice, a youth-led coalition fighting for human rights, accountability, and justice under AI. Today, I'm speaking in support of H142 and S46, introduced by Senator Cynthia Cream and Andy Vargas. I'll keep my testimony brief. Time and time again, personal data and privacy rights are overlooked and dismissed in the political sphere. And while technology has developed at unprecedented speeds, laws in Massachusetts have failed to keep pace. The importance of protecting our personal data links to our fundamental rights as Americans and humans, for that matter. Online platforms have neglected the importance of data privacy and abused our data, centering profits over basic rights. H142 and S46 protects us from these invasive, discriminatory, and abusive practices. And I'm here to tell you that if this isn't addressed today, it'll only allow the proliferation of more invasive practices, which we in the future will have to deal with. And that's why I'm urging you to pass H142 and S46 to vote to protect our rights, vote to protect our future. Thanks.
Adrian, thank you very much. You are extraordinarily articulate, and I'm very glad to see that you are here representing your generation. I'm sure in many respects, you are going to be dealing with this at an intensifying level as we move forward. So I'm really grateful that you took the time and are interested and engaged in this issue. It's a very hopeful sign, and appreciate you being with us today. Are there any members of the committee who have any questions or comments for Adrian? Okay, well, listen, keep that engagement up, please. It's really important for your generation, very important, and thank you very much. The next to testify, if she is still here, is Julie Bernstein. Julie, are you here still?
I am indeed. One moment, please.
Certainly.
Chair Finegold, Chair Campbell, and members of the committee. My name is Julie Bernstein. I live in Dover, and I'm speaking on behalf of Digital Fourth. Currently, it is virtually impossible to shield your personal information from commercial interests. I support H142S46, the Massachusetts Information Privacy Act, because it moves Massachusetts in the right direction to protect us from the dangers of corporate monitoring and sharing of our personal and private data. Since the advent of the pandemic, many of us have been ordering more items online. The simple act of looking at various choices on Amazon leads to the collection of information about our personal lives. A woman expecting a child who begins to search for books about pregnancy online is likely to soon find herself flooded with advertisements from countless sources for baby care items. She didn't solicit these and should be able to opt out of them. Perhaps this same woman was hoping to keep her pregnancy secret for a while. Currently, there is nothing to prevent the same platforms from passing this deeply private information on to a third-party data broker who might sell it to human resources at the company that employs her. Perhaps this leads to her boss scrutinizing her work a little more carefully so he can find a reason to fire her and hire someone else before she's even publicly announced her pregnancy. Recently, U.S. Catholic Bishop Monsignor Jeffrey Beryl was forced to resign after a Catholic news outlet reported that he had visited gay bars and private residences while using Grindr. This news outlet obtained commercially available location data from a vendor, which means that in the absence of protections enshrined in MIPA, you or I are equally vulnerable to having private details of our lives exposed to our employers, or for that matter, to everyone. I was intending to use the remainder of my time to discuss several aspirations that we have for the future role that the information privacy established under MIPA might have in addressing other privacy issues, including the constant monitoring of Amazon warehouse workers and delivery drivers, the biased mortgage approval and credit scoring algorithms that adversely affect people on the basis of living in certain zip codes or having less access to classical ways of establishing credit, and the biased hiring algorithms that enforce interviewers' preferences through dynamic learning. However, I learned about H107, which would protect students' private information and would also require schools to limit the use of technology to either replace a live teacher or for purposes of monitoring a child's work, online speech, or searches, and I feel that this act is urgent. If there is anything that we have learned from the pandemic, it is that there is a huge cost to replacing in-person interactions with those over a computer, even when there is a teacher on the screen. This is because we are humans and we are wired to interact with people, to learn to interpret their expressions, their gestures.
Julie, if you can try to wrap up, please.
Okay. And with this recognition comes a comfort in sharing and an ability to form a bond. We sometimes forget that this is a vital part of both child and adolescent development. My own children have benefited tremendously as people from conversations with their teachers. And if anything, we need to have more opportunities like this for children. We've also learned from experiences with technology and education how deeply flawed it can be. Dartmouth medical students being proctored online were accused of cheating because the technology picked up the pings that their personal computers were making to their online textbooks while they were completing an examination. It was only learned later, after exposing these students to great shame, that it was because they were connected to these textbooks throughout the term and their devices would periodically reach out to the text to maintain the connection. My own child, a couple of years ago, before the implementation of the current, even more invasive school monitoring, was faced with a situation where his teacher told the class that they had to use Google Docs so that he could ensure that no one was plagiarizing. My son loved thinking about literature, developing his own ideas, and he was very distressed. He told me that he felt as though the teacher would be looking over his shoulder as he wrote every sentence. He talked to the teacher. The teacher would not acquiesce unless he was willing to be docked a full grade. He agreed to do this, accepting a B instead of an A, because of the importance to him of being able to frame and reframe his thoughts. Kids need space to develop and explore many topics. Algorithms cannot distinguish between a child who explores high school shootings because they're terrified and want to figure out what to do if there's a school shooter or a child who is deeply disturbed and might have a desire to harm others. Yet we will expose both of these students to interrogation if we surveil their searches. Childhood is a time to explore, to learn, to figure out who you are. It is also a time to make mistakes and to experiment. I feel that H107 is crucial because we must deeply consider.
Thanks so much, Julie. We gotta.
Okay, thank you.
Yeah,
thank you.
Thanks.
Okay, are there any questions from the committee members? Okay, Robert, I believe that you have been with us for a while. I can see you there. Robert O'Konowski.
Bob, we all call him Bob, so just
yeah, it's much easier.
Bob, the Polish guy, Prospect Hill Bob, you know, we got it all. The Madam Chair, thank you very much for the opportunity to speak today. Senator Finegold, good to see you again. The Bob O'Konowski, the Executive Vice President for the Massachusetts State Auto Dealers Association. We represent the 427 franchise new car and truck dealers across the Commonwealth. We have over 25,000 employees, including many throughout the Merrimack Valley. And we represent almost 20% of the retail economy in Massachusetts. You know, I'm speaking on Senate 46. There's a lot of concerns that we as small businessmen and women have about Senate 46. But when you think about it, every one of us here on this call today is a citizen, is a consumer, should have a concern about how their personal data is used. But when you look at the legislation and how it might impact our franchise dealers, we have several concerns. First off, there's our dealers are very cognizant of and very committed to protecting personal data of our customers, whether they're sales customers, repair customers, parts customers. It's in our best interest to follow federal law, as well as other programs that are in place to protect the personal data. But one of the things that I know my fellow dealers in California and Virginia worked on was some recognition in those laws that we need to hold on to the personal data of our car customers and repair customers in order to better execute recall and warranty notifications out to those customers, as well as maintaining the repair information so that we can keep up with those customers on their needs over time. We also have concerns about on how the private right to action might be open to abuse. There's also an aspect here of cross-border commerce that we feel needs to be looked at, as we have customers across the border in every state that surrounds us, as well as we have dealers who have businesses in other states in addition to Massachusetts as part of their dealer groups. So I'm going to be submitting written testimony. I thank you for the opportunity today to testify, just to get out some issues there that you should consider as we move forward on these pieces of legislation. Thank you for the time today.
Thank you, Bob. And to all that are still yet to testify, thank you for your patience. Are there any questions for Bob? Any comments from committee members? Okay, thank you very much. I'm sure we'll be meeting Bob and discussing all of this further.
Appreciate your time. Thank you.
Thank you very much. Okay, I believe that I skipped over Drake Jamali, if he is still here with us. Drake, you're still here?
Hello, can you hear me?
Yes, I can, loud and clear. The floor is yours for 3 minutes, Drake.
Okay, thank you so much. Afternoon. Thank you to the chairs and members of the committee for allowing me to speak today on our concerns around both H142 and S46, along with S220. My name is Drake Jamali. I'm with the Security Industry Association. We're a nonprofit trade association representing many of the leading manufacturers of biometric technologies, as well as those who are integrating these technologies into a wide range of building security and life safety systems, including over 24 businesses with headquarters, employees, and operations in Massachusetts. I'll try and be brief here. Currently, we have two main concerns with the bills as they are written. First, that the safe and security applications will be undermined without an exemption from written consent requirements and security purposes. In the security field, biometric solutions help businesses keep their facilities, employees, patrons safe by increasing the effectiveness of security systems. This can range from protecting against malicious actors, fire, carbon monoxide alerts, even increasing the energy efficiency of facilities. A consent requirement makes participation optional, thus limiting the ability to effectively deploy safety and security systems that utilize biometric technologies throughout a building due to the presence of a mixed population of consenting and non-consenting individuals. At a minimum, an exemption from the bill's requirements for safety and security uses is essential. A good example is the security provision included in the Washington State's current biometric law, which was enacted in 2017. And secondly, the class action liability will reverse commercial adoption of biometrics throughout the Commonwealth. Correspondingly, the extension of private entities and individuals of the private right of action of severe consequence for Massachusetts businesses that wish to use these technologies, subjecting them to frivolous lawsuits, which has been mentioned in previous testimonies here today. And we've seen that extensively in the state of Illinois since they enacted their law in 2008, where hundreds of lawsuits have been filed and have limited services for several digital products. We would recommend that the committee consider giving the Attorney General's office the jurisdiction over these cases, which the states of Washington, Texas, and recently Virginia have done as well. And just want to end by saying thank you for your time and attention to this issue. I know that this is a very prominent issue, not just in the Commonwealth, but across the U.S. And we'll be submitting written testimony as well. And please let us know if SIA or our members can provide information further to the committee and the chairs here. Thanks again.
Thank you very much, Jake. That was very concise. And I do have a follow-up question. You had mentioned Washington State as having some legislation that you thought was reasonable and effective. If you could get in touch with the committee and let us know specifically what aspects of that legislation you found reasonable.
Yeah, we could put that in a written testimony. No problem.
Yeah.
Thank you.
That would be really helpful along with the legislation itself, so we could take a look at that.
Okay. Perfect. Thank you.
Yeah, you're welcome. Are there any further questions from the committee? Okay. I just want to thank the committee members for hanging in there and staying with us on these issues. The next individual that I have on my list is Ryan Garrity. Ryan, are you still with us? Okay, we might have to circle back. I have next John Suchich. John, are you still with us?
I am, Madam Chair.
Okay,
nice
please pronounce your name correctly for me.
Sure, it's Sudich. I don't know how it went into Ellis Island, but that's how it came out. So, good afternoon. I'm John Sudich, Vice President of State Government Affairs for Comcast here in Massachusetts. Comcast provides state-of-the-art residential and commercial broadband, video, and voice services in 248 Massachusetts communities. We also offer other business lines such as Xfinity Mobile and Xfinity Home. We employ thousands of Massachusetts residents, and between network investment, salaries and workforce training, community investment, and taxation, we put about $1 billion a year into the Massachusetts economy. I'm here to support S57, sponsored by Senator Finegold, and H131, sponsored by Lita Moran. Both of these proposals would create important broadband adoption programs to help families and individuals in need. Broadband access, which means whether a particular address can utilize a broadband network, has largely been solved in Massachusetts with some very specific areas that are challenging to reach that are getting worked on with the Massachusetts Broadband Institute now. But broadband adoption is a much more challenging issue, and that's when a household has access to a broadband product, but perhaps hasn't taken a subscription due to economic or other digital literacy challenges or other sort of mitigating factors. Comcast has a program, Internet Essentials, for over 10 years now to address the challenges some families face in affording a broadband subscription with a $9.95 a month product that includes modem, access to digital literacy classes, and access to a low-cost computing device. It's been tremendously effective in the communities we serve, but even at that low price point, it has been a challenge for some families, especially through the pandemic. The federal government recently launched its emergency broadband benefit program to support broadband subscriptions, but in our experience, it's wise for states to have complementary programs to further support families with financial need, as we do in other subject areas such as healthcare, food insecurity and nutrition, or housing. We will be submitting substantial written testimony on these and a number of other bills on the committee is hearing today, but we felt that it was important to testify in support of these important broadband adoption bills. So thank you very much for the opportunity to testify, and I'm happy to take any questions on anything the committee may have. Thanks for your time.
Thank you very much, John. Any questions from the committee? And we want to thank you for previous testimony as well, and the work through the pandemic, which is the need is going to continue, and we appreciate that.
Yep. Well, we really appreciate this committee. It's really probably very important that the legislature saw fit to break out these various areas. Very complex, very big issues, as I think we've all seen today, just on these issues alone. So thanks for the time for all of you, and hang in there today.
Thank you very much. Thank you. Any other questions, comments from the committee? Okay, I'm moving on to John Cox. John, are you still with us? Okay.
Yes, I am. Yes, I am.
Okay, John, the floor is yours for 3 minutes.
All right, Chair Finegold, Chair Campbell, committee members, thank you for allowing me to comment in support of S48 and S49. I'm John Cox, president of Cape Cod Community College. Over the course of the COVID-19 pandemic that has run across 3 academic years for all of our colleges, we've learned a great deal about the resiliency of our students, faculty, and staff. We've experienced an exponential growth in my college's laptop loaner program to a distribution of over 300 units to serve students and even faculty, while providing the CPU capacity to access the data-rich downloads from the internet and the horsepower to run Zoom and Teams. Many students lack high-speed internet access. With the help of private donors, we provided students assistance of up to $250 to offset internet access charges, many times in addition to the essentials programs available through the internet service providers. Our programs began prior to the federal CARES funding. We also wired our parking lot for secure web access while buildings were closed due to COVID. During the pandemic, we rediscovered the digital divide and a level of tech insecurity and anxiety among not only students, but also faculty and staff trying to maintain reliable high-speed connectivity in a world that became online and remote. As we've navigated the pandemic, the world is reopening and the future of education and work increases the need for affordable, secure, high-speed internet connectivity. It's become a fundamental utility of society. Equal access to the internet, whether by cable, fiber, or Wi-Fi, is a basic need requiring the service of the common carrier utility and the responsibility to connect and support affordable, reliable access. On behalf of my student, who found herself competing with everyone at home for basic internet access, sharing a computer, and occasionally tying into unsecured networks in public spaces, Senate Bill 48, the Internet Freedom Act, recognizes the need for affordable, equal access to the internet. And Senate Bill 49, the Massachusetts Broadband Competitive Marketplace Study, sets the groundwork for a systemic approach to ensure the Commonwealth moves forward with competitive, equal access, and affordable broadband. S49 and S48 will not only enhance the teaching and learning capabilities for our students, but will support social justice and the very social economic fabric, the technical infrastructure that serves as a foundation of civil society through equal access to affordable, reliable broadband. Thank you for your consideration and support of this legislation.
Well, thank you so very much, John. It was said very eloquently, I believe. Your connection to opportunity, which is what you bring to the Commonwealth. I want to thank you for that and your public service for sure. I think you were able to communicate that link to opportunity and how critical this is in that regard. So
very much.
Today, yes. Are there any committee members that would like to comment or question? Okay, thank you very much. I'm sure we'll hear some more from you. Okay, this name I'm going to get incorrect here as well. So please feel free to correct me. David Chauvenet. I'm using French here. I'm probably in the wrong nationality again, but David, are you still with us?
I am still here. Can you hear me?
Yes. Can you please correctly pronounce your last name for us and tell us, you know, where you're from or any organization that you're representing?
Sure. So I'm David Chauvenet. It's actually easier than it looks. Yeah. So first of all, I want to thank you all, members of the committee, for this opportunity to testify today. I'm an associate professor of computer science at Northeastern University. I'm also the executive director of Northeastern Cybersecurity and Privacy Institute, and I'm also a member of the Commonwealth's Broadband Equity Commission. So first of all, just right out the bat, I want to say that I support the proposed legislation, strongly encourage its adoption. My team at Northeastern has been measuring net neutrality violations in the Commonwealth for the past 6 years. Our ongoing data collection and rigorous peer-reviewed analysis demonstrates that there are actually harms from net neutrality violations that continue today. So nearly all cellular service providers in the Commonwealth throttle or slow down network connections specifically for video streaming services. And that in turn limits the quality in terms of the video that you can get. So this will affect not only services used for entertainment like Netflix, but also those used for many other public goods. So consider a student who must engage in remote instruction, and that instruction includes watching an educational video on YouTube. The video quality may be so poor due to throttling that they can't even make out the writing on the screen. The students in this situation may have no other way to access the instructional material, putting them at a disadvantage through no fault of their own. In addition, my team has studied the way that network providers decide when to throttle applications, and their methods are imprecise and incomplete, which creates a patchwork of throttling practices that in turn creates an unlevel playing field for different content providers. The last thing I want to talk about in terms of my research is that this is not what we would consider reasonable network management. Network operators would tend to do throttling or slowing down traffic when the networks are overloaded, which tends to happen at certain points in time and space. But what we observe is the throttling happens 24/7 everywhere, not in response to temporary overloads. So as Senator Eldridge pointed out earlier today, unfortunately, we cannot rely on federal action on this matter. We've seen a failure to pass net neutrality laws, and in the absence of those laws at the federal level, we've seen a shifting regulatory environment. Even 266 days into the current Biden administration, there still hasn't been a nomination for a 5th FCC commissioner who might reinstate federal net neutrality protections. So I would argue that we need action on this bill so we can protect residents of our Commonwealth today without waiting for federal protections that may never come. So thank you again for the opportunity to testify here today, and I'm happy to take any questions you may have.
Well, thank you, David, for bringing your expertise to this hearing and to the committee. It's greatly appreciated. I will open it up to any questions that any committee members may have at this time, as we have this expert here with us today.
Okay. Madam Chair, if I might. Hi, Representative Sally Kearns. Thank you, David. This might be beyond the scope of what you looked into, but do you have any sense of the degree to which teachers are even aware that this is a thing, that their students, please.
Yeah, that's a great question. So we have not directly studied this. I'll start with that. But I think most people in the Commonwealth are not aware that this kind of throttling happens. It tends to be disclosed in fine print. There is still a disclosure requirement at the federal level. That was like one of the few things that the Occupy FCC left in place. So these things are disclosed, but most people are completely unaware. They have no idea that their video services are being slowed down.
That's incredible. Thank you.
David, is it too simplistic, or could you give us an answer as to what time of day or evening this typically peaks?
Are you asking when do we see the throttling happen?
Most often,
so
any particular time of day or evening?
Right. So that's a great question. So, what we found is that the cell providers that engage in throttling, they do it 24/7. It doesn't seem to correlate at all with whether the network is overloaded or not, which is why, as I mentioned in my testimony, we don't consider that a reasonable network management practice, because if what we would consider reasonable is you're responding to a network being overloaded. And they seem to just apply these policies 24/7. So honestly, it's not entirely clear why this needs to happen in this way. And there's other ways that network operators can manage their networks that don't have to single out specific applications like video streaming.
Okay, thank you. Thank you. Rep. Kearns, did you have a follow-up question, or am I just catching that now?
No, I'm good. Thank you. Sorry. Is my hand up? Sorry.
No worries. Delayed reaction here. Okay, are there any other questions from any committee members that are here still? Okay. I just got a note that Rep. Senna has joined us and would like to testify. Rep, would you like to comment or testify if you are here? Okay, we will continue to try and catch. Okay, the next individual I have to testify is Ryan Sengel. And Ryan, I have seen you out there. Are you still with us? Okay, we will circle back if Ryan reappears. Oh, there he is. Ryan, are you still with us? You're going to have to unmute.
There we go. Sorry, can you hear me?
Absolutely, no problem.
Fantastic. Thank you so much, Madam Chairman. My name is Ryan Sengel. I'm a two-time startup founder and an open internet fellow at Stanford Law School's Center for Internet and Society. I'm testifying here today in my personal capacity, though. I'm here to support Senator Eldridge's net neutrality bill S48. In 2017, the FCC took the radical step of abolishing all net neutrality protections. And it did that by saying the FCC had no authority over the companies like AT&T and Comcast and Verizon that we pay to get online. So that reversed nearly 2 decades of federal policy. So for instance, the FCC's first action on net neutrality was President Bush's FCC chair, Michael Powell, going after a phone company that was blocking online calling. So we now have a regulatory void at the federal level, right? Millions of Americans filed comments trying to oppose that repeal by Ajit Pai's FCC. The big ISPs paid firms that submitted millions of fake comments, trying to make it hard to see who supported what. But a study I did found that more than 800,000 Americans filed comments that weren't form submissions and that were written in their own words. Nearly 20,000 of those came from Massachusetts. And even in a small font, that's a 1,200-page PDF. I'm happy to share that with you all, and you can read through it and look for constituents to see them. But it's overwhelmingly clear that Americans and Massachusetts residents want protections that ensure an open and free internet. S48 is the best proposal before you to restore those protections. Right? The 2015 Open Internet Order was 3 pages of rules and 300 pages that explained and clarified the rules. S48 is modeled closely after California's law, SB 822, and both of those contain all of the key protections from the 2015 order, and they close the known loopholes that ISPs have and continue to exploit. And it does that by also creating clear rules of the road for all the market participants. Other proposals before the committee either require redoing all the FCC's work or hoping that a transparency requirement will prevent bad behavior. Right? As we just saw from the testimony from the professor, that transparency requirement doesn't really work. So if Massachusetts passes S48, it will become only the second state in the nation to truly restore the level of protection we had prior to the 2017 repeal. And I would say, contrary to assertions by Mr. Wilkinson, state level net neutrality protections are legal. Every time the ISPs have argued that to the contrary to a federal court, and the courts have ruled on it, they have lost, right? California was cleared in February to start enforcing a bill that's nearly identical to S48. And finally, I'll mention, it's a little bit odd to hear the ISPs come in to tell the state of Massachusetts that you have no right to protect your citizens, but please will you give us money for what we think is a utility. So, if it's important enough that the state and the federal government should make sure that every citizen has a right to access internet access, we think that it's fair that there are fair rules of the road that make sure it's open for everyone. Thank you for your time.
And thank you for sharing your expertise with us, Ryan. It's very helpful. Are there any questions from the committee members or comments? Okay, seeing none. If there's any way that you think this current legislation that you're supportive of can be improved, please send us that in writing as well. That would be helpful.
Great. I will submit written testimony as well. Thank you so much.
Okay, thank you. Okay, and I believe that Rep. Senna might be back and might be able to join us now. Rep, are you with us?
Hi, yes, thank you. I'm sorry I walked away for a little bit.
Oh, most welcome, most welcome.
Well, I'm here in support of H137, and I want to thank the Chair Finegold and Chair Campbell for the opportunity to speak here today. And I would like to ask the committee to report this bill out favorably, if possible. This bill is very important. It would mandate the Department of Housing and Community Development to require public housing and be able to provide free broadband internet as part of offering, a home or a safe place to live. And in addition, this bill, it would basically set broadband as a human right. And we all know that through COVID times, it really became so important that we all have access to internet, it's particularly to health, being able to communicate with the doctor. So this bill is very simple. I think that's all it does. It provides free internet for people that resides in public housing. And I think it's this bill came along after we met with several local human services workers who identified this need and felt it was so important that we have this on the books. And I don't think I have anything else to add, and I will yield the rest of my time, but if there's any questions, I'd be glad to take them.
Thank you, Rep, for making the time to be with us today, and appreciate it. And like you said, I think it's a pretty straightforward matter that's before us. And I don't have any questions, but I would like it to open it up to any committee members that are still with us if they have any questions regarding this bill. Okay, I don't hear any. Please stay in touch with us and don't hesitate to contact us on any more specifics that you'd like to discuss. We're available constantly, so thank you for your time today.
Thank you so much.
Okay, be well. Next on my list, I have Frank Clegg. Frank, are you still with us? Okay, not hearing Frank. Stephen Johnson, are you still with us?
I am with us. I'm
Okay.
here.
A very patient soul. Stephen, apologize for the delay, and the floor is yours. Please let us know if you're here with an organization. Yes, the floor is yours for 3 minutes.
Thank you so much. Good afternoon. Thank you to Chairman Finegold, Vice Chairman Moran, Chair Campbell, Vice Chair Carey. My name is Stephen Johnson. I'm the Chief Executive Officer and Executive Director of Open Cape. For those of you that may not be familiar with us, we are a 100% fiber optic network that services Cape Cod, the islands, and 38 towns in southeastern Massachusetts. All fiber connects in Providence and Boston. We primarily service federal and municipal customers, large and small businesses, schools, colleges, hospitals, a wide array of nonprofit, public safety, research organizations. During last year, during COVID, we initiated 2 residential pilot programs in Hyannis and Falmouth, and we are striving to expand those programs and also bring those services to other communities. Our state-of-the-art network is future-focused and allows us to deliver up to 400 gigabits per second to any customer on our network. Yes, OpenCape is a technology company. We are an internet service provider. We are also a not-for-profit organization. We were born out of 2009, out of the Broadband Technology Opportunity Program. And the success of that program has allowed us to grow into a strong and sustainable presence in our market. As a 501c3, our perspective is significantly different from some of the ISPs you've heard earlier in the day. Our mission is to provide local, reliable, and affordable broadband access through our state-of-the-art network and to specifically advocate for choice in internet connectivity in our communities to improve the quality of life, address the digital equity issue, and work toward closing the digital divide. I wanted to support several bills today, primarily Senate 45, Senate 46, 48, 49, 50, 52, 57, 56, 58. Sorry, I'm going pretty fast. As well as House Bill 120, House Bill 128, House Bill 141, 143, and House Bill 134. I know that's a multitude of them, and that is diametrically opposed to our competitors. There's one bill I did want to mention I have a concern about. That's House Bill 121. My fear is this bill is potentially a Trojan horse. While on the surface it seems straightforward and innocuous, but in reality, I believe this bill and what comes after it may open the door for legislation that would seek to limit the ability of municipalities to offer broadband services to their residents and businesses. This would be in direct violation of Mass General Law, Chapter 164, Section 47E. Nearly 40 communities across the Commonwealth have moved in this direction, and my fear is this bill, with its is similarly strikingly similar to other legislation that 23 states have adopted that either specifically prohibits or places significant roadblocks on municipalities offering broadband services. For me, that strategy is nothing more than corporate protectionism of the national providers. If anything, the Commonwealth needs to be encouraging more competition.
Thank you, Steve. Thank you, Steve.
Okay, thanks. I appreciate it.
Thank you, Steve.
Quick, I'm happy to answer any questions.
The number on that bill that you had opposition to, what was that, please?
121, House Bill 121.
Okay, thank you very much.
Excuse me. Yeah, Madam Chair, if I could, thank you. I couldn't hear some of what you said. Someone needs to mute because there was a lot of interference, but did you say that your concern with 121 is that it could open the door and inadvertently create obstacles to municipalities that want to offer broadband?
Right. So the bill is positioned. It's pretty straightforward as it's a study to look at the value of municipalities offering this service, but under Mass General Law, it's already municipalities already have this right, and my fear is that this is a gateway bill that would open the door to allow other legislation to follow it, which would put prohibitions on municipalities being able to offer this service. And we've all seen that this is basically an attempt by the national providers to put a stranglehold on municipalities from offering services when indeed the national providers aren't providing the type of service, the affordable service that meets the demand of today's current customers. So that's my fear. And there's 23 states around the country that are suffering under this. And luckily, Massachusetts is not one of them, nor do we want to end up on that list. So, and in my written testimony, I'll give more detail on that, and also some very specific examples of people impacted by these rules.
Thank you.
No problem.
Any further questions? Okay. The next individual on my list is Lauren Heller. Lauren, are you still with us? Okay. Sheila Reavill. Sheila, are you still with us?
Oh, yes, I'm here.
Okay, Sheila, welcome. Please just introduce yourself if you're with any organization, and please try and limit your testimony to 3 minutes.
Okay. My name is Sheila Reavill. I'm a building biologist with the Building Biology Institute. I have training in assessing the risk factors in homes and in schools as well. Prior to this, and I live in Georgia. Prior to this, I was a school teacher for 21 years. I'm a retired school teacher. And I got to witness the development of the implementation of the wireless technology in the classroom and all around the school. I didn't know what was happening, and I didn't know that there were any health effects associated with it until 2016, when I hired a building biologist and figured it out myself. Looking back, I saw so many health problems associated with the implementation of the Wi-Fi. The special ed department started to become growing and growing and growing. It became the largest department at one high school that I worked at. The school that I was at, I had heart palpitations in the classroom when they installed the Wi-Fi access point. When they turned it off, I had no problems. My principal allowed me, he accommodated me under the Americans with Disabilities Act to still teach in a non-wireless classroom. I asked all my students to turn off their cell phones at the door, and I enforced it with my meter. When they came to the door, if it went up to red, I said, do you have a cell phone? Yeah. Well, did you turn it off? No. Okay, go to the end of the line. So I had a very electrically quiet classroom. There were a few that would turn it back on, just because, they would. And I would find them, and they knew I had my meter and I could find them. So I kept it reasonably quiet in there. I was in a portable, so there was no penetration from other classrooms. I could predict 100% on the day of testing, when we had all the laptops open, all the Wi-Fi access points blasting away, there would be a bloody nose, and there was. I talked with Anura Lawson in LA Unified. I was in Lodi Unified in California, and she said the kids were getting bloody noses, they were getting bloody ears. I saw an increase in runny noses. When I started 20 years ago, we were given a Kleenex box, one Kleenex box, and that lasted us the whole year. I would have Kleenex box drives. I mean, the snot would just come out of their nose. It would just be dripping out of their noses. I couldn't keep up enough. And all of these things are symptoms of microwave sickness. I never saw any of this. In the year 2000, when I started teaching, we might have one bloody nose a year. And I was getting bloody noses, sending kids out of the classroom with bloody noses on every other week. I would send a kid out with a bloody nose. Our health started declining. Our teachers started getting declining health. We had 5. In 5 years, we had 5 heart incidents on campus. Our vice principal was taken out on a stretcher to the hospital. Another teacher, same at the end of the day, he was told to go to the hospital. He was having a heart incident. We had another teacher, she had a heart incident. She was told to go off campus, go to the hospital. I was having heart problems. A friend of mine, a teacher on campus, was having heart problems. She had surgery and they took out part of her heart to solve it, and then they gave her a wireless device to monitor it. I thought, oh my Lord. So is it time? Okay, so I'm supporting, obviously, H105, reducing the radiation in schools. It is way too high. And I've seen the health effects. Thank you.
Thank you very much. I appreciate you taking the time. We appreciate you taking the time to share your experience with us. And if you have additional information to share, please don't hesitate to provide some more written testimony to us as well. It will be read in great detail. So thank you for your time. Any questions for Sheila? Okay. I'm going to circle back. I believe I misspoke. I'm looking to see if Marvin Vinay is still with us. Marvin, are you still with us?
Yes, good afternoon.
We're right there in front of me, and I just went down that list, and I apologize.
No worries at all.
Okay. The floor is yours, Marvin, and please introduce yourself.
Thank you. Chairs Finegold and Campbell, Vice Chairs Moran and Carey, members of the committee, thank you for the opportunity to appear before you today. As it's been indicated, my name is Marvin Vinay, and I am the Director of Advocacy at Tech Goes Home. Also like to recognize our co-CEO, Theodora Hanna, who is watching, taking care of our buddy Teddy at home today. Tech Goes Home is a leading Boston-based nonprofit focused on ending digital inequity in communities throughout Eastern Mass. Currently, we are reaching about 11 gateway cities, providing individuals and families in need with internet access, digital devices, and comprehensive culturally competent digital skills training. There's been a tremendous focus on digital inequity in the context of COVID-19, which certainly exacerbated the digital challenges facing people in Massachusetts. However, the truth is that digital inequity has existed for generations and is inextricably linked to many other areas of injustice, including healthcare, housing, education, economic opportunity, and more. At a recent meeting of the Broadband Equity Commission, TGH presented and highlighted 3 critical policy improvements that are key to creating a more equitable and sustainable advancing of digital equity. Greater data transparency from ISPs in terms of the number of subscribers and their current internet speeds. Reliable availability of low-cost plans that are at least equal to retail options in speed and data caps. And accurate information on internet speed floors rather than ceilings, so that consumers understand that what they are getting, rather being sold on speeds that may never actually experience. Several of these bills considered in this hearing today would make substantial progress on these and other policy priorities to expand digital equity in Massachusetts. H139, it would keep high quality internet affordable and accessible for the duration of COVID-19. S50, and H142 would protect individual privacy, including those who may be learning how to navigate the internet. S52 would create more accessible internet access in the long run and put in place new requirements regarding cost, data, and key considerations. S57 would devote resources to expand the broadband access. H3952 would give individual greater control over the data online and prevent discriminatory. These bills are essential to expanding access to digital tools, resources, and opportunities, protecting individuals and families who are newly engaged in the digital world and holding ISPs accountable, providing high quality, accessible service to all communities. We encourage the legislator to take swift action on these critical pieces of legislation. We would welcome the opportunity to answer any questions, providing additional information, and we'll be happy to submit written testimony due by this Friday. Thank you again.
Marvin, thank you again, and thank you for your patience. And the good work that you're doing. We would be particularly interested if any of the bills that you mentioned here that you're very supportive of, and your organization as well, if there's any way you think that they can be improved or tweaked, please don't hesitate to volunteer that information as well. It'll be
Absolutely.
And again, thank you for your engagement on this and the commission as well. Any questions from anyone? Okay. Thank you very much, Marvin.
Thank you again.
Okay. Okay, I am looking to see next if Alison McDonough is here. Alison, are you still with us? Okay, we will see if Alison comes back. I now have a panel, Theodora, Scarato, and Marvin Vinay.
Hi, thank you very much. I didn't know that I was on a panel, but great. I'm Theodora Scarato, Executive Director with Environmental Health Trust, and we are a scientific think tank. We publish research and educate policymakers on preventable health risks, ehtrust.org. So I know that corporations, and I'm going to be speaking about the issue of wireless and health. Corporations use Wi-Fi and 5G to offer their products, saying it will bridge the digital divide when what we need is affordable broadband for everyone, and it needs to be wired, not wireless. So we just had a court victory in our landmark case, Environmental Health Trust et al. Versus the FCC. I'm glad to answer questions about it. What it did reveal is that at the federal level, the ball has been completely dropped when it comes to wireless and health. The U.S. Court of Appeals for the D.C. Circuit rules that the FCC ignored the scientific evidence on their record and failed to provide a reasoned explanation for their determination that their 1996, 25-year-old FCC limits applied and kept everyone safe, especially in light of the new 5G and wireless environment that we're all swimming in. Children are more vulnerable to wireless. I'm sure you've heard about this. Their developing brains are more sensitive. Their thinner skulls allow more radiation to penetrate deeper and actually more intensely, and they'll have a lifetime of exposure. Now, what the industry is saying is that our court decision was just procedural. And guess what? It was procedural. It was about proper procedure, because if you are going to unleash an exposure, you had best have fully followed procedure, which means looking at all of the evidence, making a decision based on a fully informed body of science and not just completely ignoring it, which is what the FCC did. So sometimes the scandal is not what is illegal, but what is legal. And in this country, we've had outdated safety limits developed way back on even more outdated science. And sorry.
All of a sudden the phone rang and frozen. So I don't know if that's a 5G issue or what, but somehow we have some issues with connectivity. So maybe we should circle back,
Try and circle back if if Theodora reaches out to us. Meanwhile, we have Alison, I believe, has circled back. Alison McDonough, are you still with us, or did you come back?
Can you hear me?
I can.
Yay, yay.
So, proceed and just introduce yourself and try and limit your comments to 3 minutes.
Okay, my name is Alison McDonough, and I am speaking today in support of hardwiring public infrastructure. The Cambridge Public Library is just one of the resources that I can no longer freely access because I am one of the estimated 5 to 30% of the population that has been electromagnetically hypersensitized. I can no longer use the PCs in the library's computer room, for instance, since the computers are all now connected wirelessly. The Hive, our library's STEAM initiative, is another forbidden resource for the hypersensitized. I could not even stand to stay for the duration of the safety workshop required of all patrons who want to use the Hive's equipment. Luckily, I ran into the manager as I was rushing out the door. I thought at the time maybe we could set up a separate location, just like the smoking rooms we had when I was in college, except now the small room will be set aside for non-smokers. But later I remembered something and emailed the manager. The lovely young mother, I said, sitting across from me during the safety workshop, was intensely scrolling and tapping on her wireless device for the entire duration of the seminar. If she had been required to pass even a short multiple choice quiz in order to get her badge at the end of the seminar, she would have flunked it. In short, she was a walking, talking amputation waiting to happen. Again and again, the safety seminar emphasized patrons must pay careful attention and also refrain from distracting other patrons for the safety of all concerned. So I asked the manager to please consider asking patrons to put away their devices while they are in the Hive. Almost all equipment in the Hive, came the reply, relies on smoking to function. For this reason, we are unable to fulfill your request to disable the smokers. We are also unable to ban smoking in the room. Said equipment in the Hive is essentially a lot of fancy printers. If they cannot be hardwired to the internet for the health and safety of all the library's patrons, then that's a serious flaw that needs to be remedied. Thank you.
You're welcome. Okay, Alison. Thank you so much, and I'm sorry I have to limit your time, but please feel free to contact us in writing and send us additional information if that is, if you feel that it would be very helpful. We'll read all of it, I assure you.
Okay, written stuff coming. Thank you.
You're welcome. Thank you for your time. And I believe Theodora, you have returned. And yes, and
I hit the Ethernet cord connecting my computer. I apologize. What I wanted to just say is that the Maryland State Council on Children and Environmental Health has passed recommendations that schools be wired and to reduce exposure, wireless exposure in schools. And of course, in many countries, they're already doing that. I'm sure you have all of that information. Over a dozen countries recommend that children reduce cell phone radio frequency radiation. And I just want to add that in our court case, again, which was procedural, one of the things the FCC was found to have ignored was children's vulnerability because they are more sensitive. And we are hopeful that there'll be a determination coming forward where they'll be able to look at all of the science. And you can follow us at environmentalhealthtrust.org. I'm also glad to answer any questions about the case.
Thank you so very much. Any questions from committee members? Okay, Alison, I'm sorry, Theodora, thank you for your time, and feel free to provide additional written testimony. Okay, the next individual on my list is Courtney Gilardi. Courtney, are you with us?
I am with you, and I have my daughter, Amelia. Is she allowed to go after me?
She is. You may come forward as a team if you wish. That's also preferable.
Thank you. Good afternoon. My name is Courtney Gilardi. I'm representing Pittsfield Cell Tower injured and concerned citizens, and I'm asking you to move forward Bill H-115, ensuring public institutions prioritize practices that protect the health and safety of students, teachers, and staff when it comes to the installation of internet service in schools. I will send you the 11,000 pages of published science admitted into the DC Circuit Court showing clear harm due to wireless radiation. On August 13th, the wireless world changed when the court ruled against the FCC and judges called the 1996 levels arbitrary and capricious and failed to take into consideration the impacts of long-term wireless exposure, the impacts to children, those injured by wireless radiation, and impacts to the developing brain and reproduction. These are the judge's words, not mine. We need actions now as our children are not being protected, and we are asking you to pass this today as an emergency measure as we cannot wait for the federal government to make these changes. Yes, this is a digital disadvantage issue. Private and more resourced schools and other countries provide safe, secure, fast, hardwired connections. Poorer private schools can't because wireless and hotspots are being peddled as cheap answers. I walked into my daughter's school for open house night. I sat in her seat and had a searing pain in the right side of my head. And when I turned to look, there was a wireless access point right there on the wall. Our children, staff, and students deserve better than this. How many behavioral problems have we heard today and physical problems have we heard described today that can be in part attributed to the wireless radiation? How many teachers wish children could sit and concentrate without being anxious, agitated, or needing to see the school nurse over a stomach ache or a headache? Don't we owe it to our public school staff and students to reduce their exposure and provide them with the safest learning environment possible so that teachers and students are set up for success? As we teach health classes in school, teaching children how to use a simple Ethernet cable will ensure good habits like wearing a bike helmet or a seatbelt long into their adulthood. It is nothing less than a public health, social justice, and child endangerment issue to continue to ignore the doctors, pediatricians, and parents asking you to do right by our school children. Thank you so much for your time today and for passing H-115. Thank you.
Courtney, thank you very much for taking the time to be with us and for your patience. It's been a long afternoon. If you have any additional information to share with us, please feel free to do so. It will all be read over very carefully.
Thank you so much. I really appreciate your consideration, and I appreciate you letting us go later in the afternoon so that my daughter Amelia, who's a school-aged young person, can also provide her testimony to each of you today.
Okay, Amelia, welcome.
Thank you. and good afternoon. My name is Amelia Gilardi. I have a home in Pittsfield, but I've been forced to live elsewhere after being displaced due to non-ionizing radiation from an illegally constructed cell tower at the top of my street. My little sister and I both received a diagnosis of EHS, which is an environmental illness caused from exposure to wireless radiation. I am speaking in support of Bill H-115 and Representative Duffy's bills to protect children from wireless harm. When I was 12 years old, I never wanted to be harmed by wireless radiation. I never wanted to lose my health and my home to it. Here I am today asking for your help in protecting us from it by passing these bills as an emergency measure. These wireless safety bills have been in the Senate for 6 years, and yet no action has been taken to protect the health of the children in the schools in the Commonwealth. My little sister has 6 years of schools left, and I hope it doesn't take that long to make our schools a safe place. If you know our story, as our neighbor and state rep Tricia Farley-Bouvier does, you heard the wireless radiation in our neighborhood has measured between 500,000 to 1 million times higher than it was previously, and 17 people became sick. Radio frequency radiation is an environmental toxin and a carcinogen. The American Academy of Pediatrics and over 250 scientists and doctors have been calling for wireless protections for children for the last 10 years, as the FCC's antiquated standards are not protective and there is no science that exists anywhere showing the cumulative long-term exposure is safe. My sister and I get skin rashes, headaches, dizziness, and nausea to the point of vomiting in the presence of wireless radiation. For some kids, it shows up as behavioral issues like having a hard time sitting still, anxiety, and acting out. Last year, my sister's teacher guessed that he would have low clean green readings of RF radiations in his classroom. When the principal used the meter, the readings, like on Cece's meter, were high to extreme. And that is what we are exposed to, this environmental toxin for 7 hours a day. Reducing wireless radiation does not mean not using technology. It simply means using fiber. An inexpensive Ethernet cable allows me to connect my Chromebook, laptop, and tablet to the internet. I have a safe, secure, fast connection with no dropout or lag, and most importantly, no EMFs, no radiation, no headaches, no nausea, and no vomiting. Please don't ignore us. Please don't wait 6 years until my sister and I have graduated from high school before you pass these bills. Just because you can't see, hear, touch, smell, or taste wireless radiation from industrial routers, access points, and the thousands of devices being used at the same time in schools does not mean the students, staff, and teachers do not feel it and are affected by it. Thank you so much for passing these bills.
Well, thank you very much, Amelia, very much for your testimony here today.
Thank you.
Are there any
Madam
questions?
Chair?
Yes.
Madam Chair, thank you so much. I appreciate your patience this afternoon. This has been a very, very full agenda for both the chairs and the members of the committee. And not only are Amelia and Courtney my constituents, they are my neighbors. The cell tower that was constructed in our neighborhood indeed was done so illegally. And that is something we continue to dispute. Hearing the stories of the closest neighbors has certainly opened my eyes to something I didn't even come close to understanding before. I think something I could say that might be helpful, and that is repeating the words of the health director of the city of Pittsfield, who said, well, not everybody is allergic to peanuts, but some people, if you give a peanut butter and jelly sandwich to, it is very, very serious. And I think that might be a way for the rest of us to understand how very, very serious this issue is for really a large part of our population. So I think we need to take this issue very seriously, and I hope that we can get support out of this committee. Thank you, Madam Chair, Mr. Chairman.
Rep. Bouvier, thank you very much for your engagement on all of these many issues today, and for providing your constituents the opportunity to bring this issue forward in their own words. It's very, very helpful, and we wish them well, and we wish them better health moving forward, and we'll, I'm sure, hear more from you as well on their behalf. So thank you so much. Okay, I believe the next person on our list is Charles Beatty. If Charles is still there. Charles, are you still with us?
Yes.
Charles, thank you for your the floor is yours. Please, if you would, introduce yourself.
I'm sorry, I can't. Oh, hi. Yeah, I'm Charles Beatty. I'm just here. I'd like to read my support statement for H107, an act regulating privacy and technology in education, which includes pre-K through higher education, including virtual schools.
Please do.
Yes. A survey of more than 577,000 students ages 11 through 15 in 42 countries found that boys who spend 90 minutes and girls who spend 60 minutes an hour on screens were much more likely to be depressed. The more time logged, the more depressed they were. The more time active outdoors, the happier they were. This bill seeks to encourage less time using technology and also ensure technology is regulated for safety, health, and privacy. A key element of the proposed bill is the provision that when educational benefits are equal between use or non-use of information technology, non-use shall be preferred. While this cannot apply to virtual schools, what is included is that virtual schools are required to provide greater access to teachers. In this bill, technology requirements are minimized to allow school districts, teachers, and students more choices, such as allowing options like Montessori or Waldorf programs. In H107, the existing Massachusetts accountability laws were amended to require attention to privacy, time on learning, and to limit collection of numerous data points. Where data collection exists, including ongoing passive surveillance, it must be public knowledge, and students must be able to raise objections. All data collection must have a predetermined educational benefit for students. Educational institutions are to set data processing agreements with IT providers to limit data collection only to the bare necessities. These contracts and data transparency will help ensure privacy. In terms of safety, H107 requires that educational institutions adopt best practices for safer and healthier technology, such as with respect to chemical concerns, electromagnetic fields, digital motion sickness, and eye rest. Please pass these laws to protect our children. I just want to thank you. No, that's it.
Charles, thank you very much for taking the time to be with us today. I think what you have testified on is a concern to, I think, many parents and many educators. So thank you for being with us today. And I will open it up to any committee members that may have any comments or questions.
No, I just want to echo, I appreciate everyone sticking around as long as a long hearing today. But this is something that's very important. As we mentioned, data privacy is just so important. And we'd love to to work on a bill that can build a consensus, because it is important to have a fair balance between interests of those who are really concerned about privacy, at the same time also make sure that we create a friendly business environment as well. So it's finding that natural in between, and that's what I'm hopefully that we can do as a committee. But it's something that's very important, and unfortunately, I don't think our federal government's going to do it anytime soon. So I do think we have to step up and do something.
Well, thank you so much.
No, thank you to all who have testified today that are still with us. We ask you to submit any additional comments that you would like. And we heard a lot of testimony today on the needs, as Senator Finegold mentioned. There is a tremendous need to address this issue, we anticipate little federal action at this point in time. So achieving that balance, as you mentioned, is critical, and we look forward to hearing some more on this particular issue as we move forward. But appreciate everyone that took the time today. So I am not hearing anyone or seeing anyone on the screen. Our research directors, I want to thank you both, Justin and Christopher, for your work in preparing for this hearing. Thank you very much. Excellent work as always. And we will be having another hearing and we'll continue this discussion. So with that, I motion to close the hearing and need a second.
So moved.
Second.
Thank you very much. I'm sure we'll all be speaking shortly. So thank you very much for your time, everybody. Take care and do well. Okay.
Thanks. Thank you.